Are there any last-minute issues we need to discuss?
The only thing is, Judge, we're talking about the division of time, and I think we're in agreement. I'm going to go an hour and 15 minutes to start, and then 45. They had objected to an hour and an hour. That's how we worked it out. The second is that I would like to have Mr. Whitney be able to do approximately 20 minutes of this when we get into the math of the award based on the complexity of the jury instruction, not the instruction so much, but the verdict form. So if the court has no objection, we'd like to split it up that way. I will do the vast majority of it, and he would handle just one certain section.
Please, the court, I don't believe I have any objection to Mr. Whitney's involvement. We did not, however, ever reach an agreement regarding, 75-45. We believe the split should be 90-30, and that's about as much of a rebuttal as you can ask for.
75-45 works for me. Anything else? Can I? Nick?
Judge, we have one
Defense,
other
plaintiffs.
issue.
I have one thing very briefly.
Ms. Crowell is your next.
Mr.
I just need someone who's ready to go.
Yeah, I am. I'm an encroacher. We are requesting the instruction of the Munchausen proxy diagnosis. As the plaintiff has indicated in court, they are not seeking damages, nor are they seeking damages from the state for Munchausen by proxy to concern or the suspicion of the diagnoses. As I do not want to make this a theme throughout my closing argument, I thought a special instruction at the front end of this would help cure that, so that way I would only reaffirm that this is coming from the court and not just my argument.
Judge, I see no need for this. I'm not arguing for Munchausen by proxy. I think the jury has had quite enough in the way of instructions, and I don't want to do anything further to confuse what was already a confusing issue. As long as I'm not talking about it, the fact is that the term Munchausen by proxy is littered throughout the documents that they have back there, the exhibits. I think they understand the circumstances.
Okay, I'm not going to give it. The instructions are locked, and if we wanted to consider something like this, it should have been discussed with the court days and days ago. What's next?
Just an update on the exhibits, Judge. I've given 3 pen drives. They all are the same to the other side. Please confirm it just has the exhibit list on them. I know you only want one, but I wanted them to have one.
I appreciate that, and as soon as we get it, let me know so we can get it to Court IT to scan it and make sure it's,
Who do you want me to give it to?
I want you to give it to me.
Okay, all right. And so I will do that as soon as they confirmed it, which should take but a second. You just want one, though, correct?
One,
Okay. Do
one
you
and
want
only
a hard
one.
copy of the list, Judge?
I personally would like a hard copy, but certainly the jury's going to need, and there's 6 jurors, so we probably need 6 copies for the jurors. And then the 2 clerks here might want a
I
copy.
gave the 2 clerks each.
Okay. Mr. Altenburn, you're next.
Yeah, we discussed the closing argument hourly rate per count before, and I believe that is preserved, but I want to pin down one final thing. First, the PowerPoint screens they showed me had an error on it. I'm told that it's been corrected. It said $300 an hour for one thing, and then down to $100 an hour, which is what the calculations are based on. But I just want to point out one more time, and I don't know that you've seen the calculations.
I have not.
But the calculations that they're going to tell the jury about sometime in the next 75 minutes are going to ask on the personal injury claim for pain and suffering damages for Maya Kowalski somewhere in the range of $100 million, and that the total amount of damages, because primarily of future pain and suffering damages, will be somewhere in the range of $200 million. These numbers are roughly a magnitude higher than the highest range in which a jury can reasonably return a verdict in this case. And this is based on an argument that, as I've argued before, is something that is not something that can be done as a matter of law, because it exceeds the range in which the jury can return a verdict by such a massive amount that it's a legal error. Lawyers have an obligation not to mislead the judge or the jury by any artifice or by any false statement of law. And what they're about to do is an artifice and a false statement of law. And I know you're going to allow it to go forward, but I want to preserve the record that I object to this.
Anything, Mr. Anderson?
No.
Well, I mean, at the end of the day, you know I have to follow the law, and I have no hesitation in following the law,
Absolutely.
even if I don't like it, or even if I like it. So I mean, the last 2 years, you know that I do that. So if you're gonna invite error into something, you might want to make sure it's something that, if ultimately the jury gives you, it's something that will be able to be survived within the legal world. Because if not,
Every bit of economic damages is thoroughly supported by multiple experts adduced into trial, and on the general damages, Judge, the weight of case law allows for per diem per hour, and none of our rates for that are outlandish in any way, shape, or form, and we simply ask the jury to make a calculation based upon the facts and the proof in the case. We're not asking the jury to just do something out of sympathy or any other emotion other than justice. That's been our position throughout.
I think that preserves it, Your Honor. Thank you.
anything else before I take a few minutes? That's the thumb drive.
Yes, it's been checked by plaintiff's team to confirm it's just the spreadsheet.
Thank you. Sarah's going to comment with it. There you go. Yeah, I'm going to go ahead and take a few moments of a personal privilege. We are in our 9th week of this trial since the beginning of jury selection. And I want to go ahead and recognize some superior efforts of many individuals who have supported the court to make this trial possible. This trial has presented some very unique logistical challenges, and it could not have occurred without the team that I'm going to talk about here. And this trial was one of the, if not the longest trial we've had here in Sarasota County. And when I was assigned this case in the summer of 2021, we soon began planning for a trial that was to occur in the spring of 2022 that coincidentally was going to occur 2 weeks after this building opened, which of course is always a difficult challenge when you're walking into a brand new building and you've never seen how the building's going to react. But be that as it may, the trial didn't occur then, but the logistical and organizational planning continued. And it's this team that made it possible, and I appreciate their efforts and necessary contributions to make this trial a reality. And they made it possible to let me focus on the legal issues as well as the conduct of the trial, instead of having to worry about all of the other things that go into making a trial happen. First, I need to recognize Karen Rushing, who is the Sarasota Clerk of Court. And in Florida, the clerk's office is an independent constitutional office, separate from and not working for the court. But despite that structure, Clerk Rushing always supports the court's efforts and always tries to find a way to say yes whenever the court asks her for something. And she does that both here in Sarasota as well as on a statewide basis, where she's one of the state leaders within the clerk's organization. And here in the courtroom, you've seen every day 2 deputy clerks from Clerk Rushing's office, Deputy Pileggi and Deputy Clerk Kitzman. And they have had the gargantuan task of keeping track of the tonnage of the exhibits, including when we routinely redact them on the fly and with just one statement, and they are on it. and they've had no break for the last 9 weeks. And after every day of this trial, they go back and keep working for several more hours, and they routinely work well into the night, logging and organizing the exhibits. Behind the scenes in the clerk's office, there was a group of Clerk Rushing's executive team that included Deputy Clerks Plant, Kernan, Mahennies, and the Clerk's General Counsel, Miss Davy. And Miss Clerk Rushing was also personally involved on this team as we were planning. So I want to thank the Clerk's office for making this happen. Next, I want to recognize Kurt Hoffman, who is the Sheriff of Sarasota County. Like the Clerk, the Sheriff is a constitutional officer separate from the court. Again, despite that structure, Sheriff Hoffman supports the court in its functions and does what is necessary to provide a safe and secure environment for all. Now, Sheriff Hoffman is actually an attorney himself and has practiced law in this court. Sheriff Hoffman has a unique perspective, insight, and talent in running a successful security team. Now, from Sheriff Hoffman's office, Lieutenant Doomer has had the overall responsibility for this detail, and in his absence, Lieutenant Tosay has filled in. Lieutenant Doomer and Lieutenant Tosay have been available to me and many times did assist me on a 24-hour, 7-day-a-week. It was not unusual for me to pick up the phone, whether it was Saturday or Sunday, to discuss issues that had arisen over the weekend. In the courtroom, you've primarily seen Deputy DiMizio and Deputy Coley, and they have been with us every day. Also, you've seen Deputy Perez, who would have been one of the primary duties had we done this trial last year. Now, they take their role seriously and professionally, and they are always present and working to keep order in this court and keeping the safety of all, from the jurors to the attorneys to the witnesses to the members of the public. And they did it so that we all could observe these court proceedings comfortably while respecting our cherished constitutional rights. Behind the scenes, there were many others within the chain of command in the Sheriff's Office that participated, notably Captain Walsh, Sergeants Koenig, Shurtlev, and Trask, and they've also contributed their expertise to this detail. The coordination from the Sheriff's Office was superb, and I also want to thank the Sheriff's Office and the deputies personally for your continued help. My next set of thank yous goes to Kim Miller, who is the court's trial court administrator and the leader of court administration. Ms. Miller, also an attorney, works for the court directly and supports the court's needs as our go-to person to make things happen. And the court goes to her a lot. Court administration supports 32 judges in 3 counties, and none of us could do what we do without court administration ensuring that the infrastructure exists wherever and whenever we hold court. Whether we go down because a power goes out, there's a hurricane, wherever we need to hold court, they ensure that we can do it. And so Ms. Miller has a thankless job, but she does it with skill and grace. Embracing that whatever it takes philosophy that court administration has, the team in court administration that has been dedicated to this trial includes Deputy Court Administrator Hamill, General Counsel Floyd, Procurement Specialist Sotomayor, and Public Information Officer Rhodes. And I also want to say thank you to them for making this happen. Now, also under the court administration department, there are 2 indispensable departments. That one is court counsel, and the other is information technology. Court counsel is a scarce resource. We only have about 7 attorneys available to assist the 32 judges in our circuit. So you can do the math, 7 attorneys to help 32. And they help us with legal research and writing. And, you know, as we are sitting here in court all day, it's difficult for us to be doing all these other things. Now, generally speaking, court counsel's time is prioritized to criminal matters and other due process type cases. And so circuit civil judges like me very rarely are allowed to use court counsel and only get it in isolated instances. Now, for this case, though, the chief judge and the trial court administrator have allowed me greater access to court counsel, given the quite a few rulings that we've had to make in this case, and that's probably by a factor of 100. But I'm going to be eternally grateful for court counsel's help during this trial. Mr. Bates from the court counsel team has been on call to me, and it's not uncommon, and I feel bad, but I'd be calling him at 9 o'clock on Saturday evenings to discuss matters about this trial. And so as we work to find the best and most legally accurate and correct ruling possible, so I want to say thank you to Mr. Bates for helping me during these last 9 weeks. Chief Technology Officer McHugh leads a small but mighty group of IT professionals. Now, I know that TV folks have 2 cameras in this courtroom, but all of the other pieces of equipment are under IT's purview, and they maintain all the technological infrastructure, and they make it look easy. And they also do it on a 24-hour, 7-day basis in 3 counties whenever we hold court. So, for instance, when I go to first appearance on a Sunday morning and I've got a problem with the video feed to DeSoto County Jail, my first call is to IT, and they jump right on it on a Sunday morning. Now, in person here in this building, you've seen IT specialist Kasika come in and clean up whenever I fumbled the technology. In the background, though, every single person in this small IT office that we have to cover these 3 counties has been involved in this case, and I also appreciate their efforts because they know I'm the one that's calling them at odd times to get something to work. Over these last 9 weeks, and even before this trial began, there's been 1,800 other cases that are in Division C that are assigned to me that continue to need attention. And I'm very blessed to have colleagues on the bench willing to jump in and help ensure that the cases continue to receive the attention that they deserve while I was here with you. And certainly this case is important, and I don't mean to understate that, but so too are each of the other 1,800 cases. Those cases are important to the litigants in those cases, just as this case is important to the litigants in this case. And to me, it's like I don't pick between my children. It's just each one is important, and we need to have the attention for each one. Chief Judge Moreland, Judges McHugh, Rule, Walker, and Williams have each tried jury and non-jury cases for me while I was seated here over the last 9 months. They and others have handled emergencies, they've conducted hearings, and otherwise conducted the business of Division C while at the same time conducting the business of their division. Just yesterday was my docket sounding case management pretrial conference and initial case management date. And I probably had a docket of 300 cases yesterday that Judges Rule and McHugh tag teamed to help to make sure that that was covered. And that was just yesterday. And their assistance, of course, have made it possible. In addition to these specifically named judges, every judge in this circuit, and actually a number of judges statewide, have been very willing to listen to me and give me advice, let me talk things over, and otherwise said yes whenever I picked up the phone to call them. And I also will be thankful to my colleagues, both in this circuit and statewide, for your help during this trial. Now, no discussion of thank yous would be complete without reference to Ms. Syback, who works with me as the court's judicial assistant. Not only does she keep me organized here in this trial, but she also staffs and ensures that all the other judges that are helping me get what they need so that when those judges get on the bench, they are fully prepared. So yesterday, and the lead up for yesterday, she was also working on the dockets of those 300 cases. Ms. Syback is my ambassador to the attorneys, the parties, and the public at large, and she does an amazing job in doing it. She's a great and helpful listener to those who call the office, and she always has a kind and supportive word when one is needed. So thank you, Ms. Sybak, for that. And finally, and most importantly, I want to recognize and thank the most important people who help and support me every day. I'm very fortunate to be partnered with a wife and a son who love me and do not get mad when I devote the time that I normally would be spending with them that I'm spending on this case and the 1,800 other cases. Without their support, I simply could not have done what is necessary in this case and in other cases. And I know that they're very frustrated with me right now, but I appreciate their willingness to share me with others so we could have this trial. I will own every mistake and misstep in this case, but the success in accomplishing this trial rests on this team and the many individuals who work behind the scenes to make this possible. And we all had the singular goal of providing a fair trial to the parties in this case. And it's to this team that deserves the praise of pulling it off. Now, I have a few more observations and then we'll get to the business at hand. Here in the courtroom, we have had daily had multiple reporters and technical individuals from TV stations covering this trial. And I must say they have been very respectful of adhering to the court's procedures while they did their job covering this trial. And they did so without interference with these court proceedings. And I appreciate the substantial professionalism and how they have gone about doing their business, while at the same time allowing us to run this trial without interference. So I appreciate their professionalism and ability to observe these proceedings and report on it without becoming an issue. I also want to thank the parties' IT professionals that are here in the courtroom, Mr. Reyes and Mr. Cottrell. They have greatly aided the presentation of the parties, and they've done so quickly and effectively. And I know that I was a little skeptical at first, but they quickly won over my skepticism, and I wish every single trial I could have Mr. Reyes and Mr. Cottrell here for the parties. You have made this trial so much nicer because of your work. So I want to say thank you to the IT professionals for the parties. Behind the scenes in every office are the ones who truly run the show, and that, of course, I mean the paralegals and the assistants. Each team that is in front of me has had any number of paralegals and assistants that have made what the parties need and what the court needed happen. And I'm sure that they've been continuing to work even after the attorneys go to bed, because I can tell by the number of emails and the times that we're receiving them that they're the ones that when the attorneys say, hey, I need this done, they're the ones that get stuck doing all of the work. And my staff, Ms. Sybak and I, appreciate your efforts very much. And even if we had all this infrastructure, and even if everyone else was here, if the parties' assistants and paralegals weren't there, nothing would have happened. So thank you. And finally, the attorneys. I must say you are all very dedicated and very passionate about this case. And it goes without saying that both sides' attorneys have given their all. I know we've had our moments, but I have never doubted your all's dedication and desire to make this trial happen. And so I do appreciate, I know how tired you are, and I know you all are very much ready for this case to be over, but I do want to pause and recognize the attorney's efforts in this case, because you basically gave it your all and you left nothing on the bench. You put everything on the playing field, and I think that shows in the amount of time and attention that each side's attorneys. So with that, that's going to conclude my personal privilege. Sorry for it taking so long, but I did want to just pause and recognize everything that was needed to make this trial happen. So unless there's anything further, I'm about ready to bring in the jury. Is there anything we need to
Just a question, we're gonna go look at the exhibits, is that all right if we do that now, and we just
Do you wanna
exit the back?
go to a different,
Yes, Your Honor, you want to go to one of the mediation rooms?
go to the mediation rooms over on the side of the building?
Okay.
And so does each side have who's gonna go?
Yeah.
Yes, Your Honor.
No.
That's stuff we go from our side.
And do you need us to make 6 copies of this, Judge?
I'm sorry?
Do you need us to make 6 copies of this?
No, the verdict form?
No, I'm sorry, holding up the wrong thing. The exhibit list.
Just before we send the jury back, so each juror can have it. And one other thing, I've got the instructions for the dependency court orders. So are we okay with me giving these out at this time to the jury?
Yes, Your Honor.
Okay. Do y'all need an extra copy of it in paper?
If you have a copy.
Yeah, I've got it.
like it would-
I would appreciate one copy, Your Honor.
The 5 go to this and the 3 go there. Okay. Ms. Kitzman, are you okay?
Yes, Your Honor.
Okay. I'm clear to bring in the jury?
Yes, Your Honor.
Let's bring in the jury. Yes, sir. And at the hour and 15-minute, Mr. Anderson, after you finish, we'll take a break, and then we'll go do Mr. Shapiro. Now, Mr. Shapiro, if you need to take a break in the middle of your, let me know, or we can go straight. Okay, members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that correct? Correct. And no one from the media approached you. Is that correct? Correct. And you have not seen any media coverage of this case. Is that correct? Correct. Okay. Deputy Coley, if you could hand out. This is the dependency court order instruction that I previously gave you during the trial, and I said I would give you a copy for your use back in the deliberation room. This is that. I'm not going to read it to you, but I've already read it to you during the trial. But you can keep that and take that back with you. Now, members of the jury, we are now ready for our closing arguments. Both sides have equal time. Under our procedures, the plaintiff is able to divide their time. The plaintiff will go first, then the defense will go, and then the plaintiff will use the remainder of the plaintiff's time in a rebuttal argument. But both sides have equal time. With that, where did Mr. Anderson go? There you are. I couldn't see you there for a moment. You have the floor, Mr. Anderson.
May it please the court. So this is closing argument summation. And, last night I couldn't sleep very well, obviously, for all the reasons. And I was rolling around, and then I woke up, and it just came to me that we've been spending 9 weeks together. And you know what I know. And I know how I reacted to all the facts. And realizing that, suddenly I just had a great sense of comfort and confidence. And I went to sleep like a baby. Because I don't have to do that much convincing, nor would I try to do that much convincing. I'm going to try up here to make some connections for you, to try to help you back there, to give you some tools to work with. Now, I'm going to be up here the first time for about an hour and 15 minutes, out of which about 20 minutes, Mr. Whitney is going to come up and help with some of the verdict form math. That is not my forte, so we decided to split it up right there and give you the best we could do. And then a couple hours for these guys, and then I'll come up for a final 45 minutes and rebut whatever they're saying and make some closing arguments. So what we have here is a great American family, right? They're hardworking. They are devout. They are patriots. They have done everything a family should do. And none of what happened to them should have happened to them. It should not have happened to them. Your job is to figure out why it happened to them, how it happened to them, and what ends up being justice for them. In this case, for reasons that I still cannot fathom in many ways, Johns Hopkins doctors who are supposed to do no harm just blew up this family. It's beyond me. And I just have a difficult time understanding motivations. I understand more based on what we heard there at the last from Dr. Cochran about some of the whys of how it would happen. And Nick has reminded me, and I want to say this out of the box, for certain reasons legally, when I say none of this or all of this, this that I am talking about is what happened to Maya back with Ms. Beatty. That is what I'm talking about, that period from October 7th through January 14th. That's what I'm saying when I'm saying this, none of this, or all of this. So the problem here is that by what pressures they put on Beata Kowalski, they took her out of the game. And she was, without a doubt, the quarterback of this team. Jack is an amazing man. But Beata was a force of nature. And Beata was capable of incredible amounts of work, tenderness, love, compassion. But she was also of an Eastern European background, and she could be brusque, but she was a lioness protecting her family. And we get into eventually what happened on that October 7th afternoon and evening. And I want you to think about one thing. If Johns Hopkins had not changed its diagnosis that quickly over that particular day, for reasons we'll get into, none of this would have happened. And that's medical malpractice. They did absolutely no research. They did not bring in experts. They did not have anybody who knew what they were doing examine Maya. And from the Kowalski standpoint, 6 days before, they had been back in with the same complaints, which is gastroparesis, which is from CRPS, right? And here they come in 6 days later, and it's completely changed. Now they're somehow treated like criminals. They're treated as though there's something wrong with them, even though, and consider it from their point of view, they've been coming to this hospital since literally before any of the CRPS symptoms started. They'd been going there for 15 months, and they'd never had a problem. They'd had support. And let me tell you, I don't think that everybody at Johns Hopkins All Children's Hospital was bad, wrong, or evil. There were some good people over there. Some of their outpatient doctors were superb. But something was very wrong with this hospital. And as I was saying, I think Dr. Cochran got to the heart of it with the culture there. It seems to me that any time you put together an organization where no one can speak up, no one can comment on anything that's going to rock the boat, you're going to get this type of situation. You're going to get a situation where a Kathy Beatty can run wild and no one will catch her, no one will slow her down, no one will get her out of this and away from Maya. There simply was no accountability at this place, none. So, what you're trying to do now, and the way I was really thinking about it was, why don't I go through some of Johns Hopkins' defenses? Because I figured that if we got rid of the defenses, then all that would be left would be our case. And then it would be much easier for you to make up your minds about things. So if you look at some of their theories that we heard in the opening statement, one was that Maya had come in emaciated and they saved her because they put weight back on her. If you check out Dr. Wassenauer's weight, she was 27 kilograms 1 week before she went in there, and she was 27 kilograms when she was out 2 weeks later. So that theory's gone. That they had kept her off or gotten her off a bunch of drugs. You can look at the admission to see what meds she was on at the time. You can look at the discharge summary and see how similar it is. Nothing there. Nothing there. They argued that ketamine bad. Ketamine bad. Ketamine scary. Ketamine worked. And they themselves, in their own routines and methodologies, they actually had a ketamine infusion process. So it wasn't the fact of infusing ketamine. What it was dosage. And they tried to scare everybody with the idea that these dosages were extraordinarily high. They worked, didn't they? They worked. And you know this because if you take a look at the progress through January through August of 2016 and the videos we showed you about how well Maya was coming along here, you can see how well they worked. Through all of this, keep in mind there was never a bad lab. Usually, if there's a drug that's going to really mess you up, if you are having some significant problems, one of the things you do is you look for the blood test for the liver primarily. What you're looking for here is to see if there's any substantial changes. Nowhere can they show you any continued or even, I don't think, any abnormal liver tests. That's an objective test that would tell you whether or not this was the wrong medicine or that there was too much medicine. They argued that Maya's recovery was all due to them. Well, no, it really wasn't. And she didn't really recover. She did much better. CRPS, as you know, is a disease that she's going to have the rest of her life. It's something that you manage. And so by taking her back so many steps, they made things so much worse for her. And it was only Maya's self-discipline and will. And I believe the idea in her head is that she wanted to prove to her mom that she could overcome, that she could do this. But it had nothing to do with Johns Hopkins All Children's Hospital. And she was not cured. And she did not end up with no symptoms. On November 20th, she ended up with a terrible relapse. You'll see the photos of her with a feeding tube down her nose. And I mean, the one thing that struck out with me was that if you looked at her clavicle right here, she didn't even look like the same girl. That's how bad that relapse was. And then if you look at Dr. Henschke's records, you'll see that she had another one in 2022. It was simply, Maya had not recovered. Everything that she did herself. And in spite of Johns Hopkins All Children's Hospital. So, what else have they tried to say? What are their other defenses? Well, they blame Beata for taking her own life. And although we'll get into a lot of this more, the fact is that Beata was reacting to a maternal instinct that she had almost no, and in fact, no ability to control. It was the same thing as a mother jumping out in front of a truck to push her 2-year-old out of the way, knowing that it would take her life. And when there's a competition between the maternal instinct and the self-preservation instinct, the maternal instinct is going to win each time. Now, let's start on a couple slides here to get rolling. The concept here is that none of Johns Hopkins' defenses that they put out in their opening or tried through the course of the case ever panned out. What they did in this case was pick around the edges and try to convince you that somehow you should doubt this poor girl, that somehow you should doubt Beata. And here she is with a relapse. Let's start at the beginning on the slides if we can. Friday, October 7th, 2016. Before this was an incredibly happy family and a good, strong marriage. And a mom who was overwhelmingly in support of her children. She was proud to be Polish. She was proud to share her heritage. And the focus of her love were her children. She loved Jack, but those children were the center of her life. Jack Kowalski is an amazing man. And one of the things that I really resented through all this is the idea that this man, who is a deputy fire chief, who ran into burning buildings, was somehow a Casper Milquetoast and wouldn't take any steps to control his wife. That is about the farthest thing from the truth. He's a quiet man. You saw him on the stand here. But in no way, shape, or form does he lack for bravery. Next one. And then 99 days later, I want to talk about the big overview of this. They go in, a happy family. Maya has CRPS, but Beata found a way. She worked her rear end off, locating the right physicians. Does anybody notice that all of the speculation about conversion disorder all came about before she was diagnosed by Dr. Kirkpatrick? If you look after that point and up until January 7th, nobody thought about that after the proper diagnosis was made. And all of the hospitals that considered, and never even diagnosed, but considered conversion disorder had one thing in common. They missed the CRPS diagnosis, right? So if you look after September 23rd of 2015, after Dr. Kirkpatrick made the appropriate diagnosis, you see that all tapered off because now they knew. Now it made sense. Beata finally got Maya to somebody who knew what they were talking about. She had solved the problem as best as the problem could be solved. CRPS is not something you can solve completely, but you know what? She found a way. She found a way to deal with it for her little girl. She found a way to get through this to the best of her ability and Maya's ability and give Maya the best life she possibly could. She went to doctor after doctor after doctor, searching. All of those that they want to blame on her somehow, that Beata was going to too many physicians, this was all before it was actually a diagnosis made. Of course she's going to do that. She's going to try to find an answer. And she found an answer. And I suggest to you that but for what Johns Hopkins did to this family, it would have been in control. And they would have gone on with their lives to the same successes, and they would have overcome this disease. And they could have gone on very, very happily with Beata there, and each of them able to live their lives as they wanted to. Afterwards, coming out, what do we know? Well, we know that mom's gone. Daughter is so weak she can barely keep herself upright in the car and needs pillows to be able to support herself. We know her CRPS is immeasurably worse. We know the family is in tatters. They have lost in many ways everything that made them up. They still have the love for each other, but they lost the driving force. Nothing was cured. Nothing was made better. Nothing was done to justify that time in there, except, of course, make Johns Hopkins a little more money, about $534,000 worth. Here you see she still had the dystonia. And you know what? I had 4 doctors come in talking about about CRPS, and I could have called more, but I figured you'd had just about all that you needed to hear about CRPS, right? So I didn't call everybody that possibly treated her. I was on the clock a bit. What I did do was try to get through enough of them so you would understand exactly what was going on here and be able to identify it. And then I used video and audio and photographs to demonstrate all of the symptoms. I don't think there's any question but that Maya has and had CRPS, which then raises the question of why were these doctors on that day? Why did they shift from the diagnosis in all of their records up to that point of CRPS and go back to some psychosomatic thing? Why would you do that? Why go back to something that 4 or 5 different experts had, why would you abandon something 5 or 6 experts had confirmed and go back to something that you could only find pre-diagnosis and as speculation from a lot of other hospitals? Not even a lot, 2. And if we can continue on, let's go. So on October 1st, as I said, she comes in and she's got the same thing, abdominal pain worsening. The diagnosis is what I was saying, regional pain disorder, which is the same thing as CRPS, right? She has a milkshake. After ketamine treatment, she goes in, and here's what happens. She was only in for about 24 hours, right? And she came out, and they had dealt with it. The same thing would have happened on October 7th, but for whatever went on that afternoon and evening. She would have been in and out and continued on her way to recovery. Next one, please. So what happened on October 7th, 6 days after the last time she was in for exactly the same thing? And keep in mind, she had been into this place over 17 times before this. Don't you think if there was some sort of psychosomatic condition, the over 50 doctors that saw her beforehand would have found that out? Couldn't they have figured that out? The Johns Hopkins doctors. She'd even been admitted twice before this. They were locked in to a confirmation of CRPS. So you've got Jack showing up. It wasn't Beata. It was Jack bringing her in. And she's in extreme pain, over and above the usual CRPS pain. Now, I don't know what went on here through all of this, but I have an idea. They find out from Dr. Hanna that she's getting ketamine booster treatments. Dr. Hanna lets them know, and they already basically knew, and in their records was Dr. Kirkpatrick diagnosing, an expert. Everybody knew. How did it change so much? Let me go again. I will come back in a moment to what I think really happened on that evening. But there was some confrontation. Something happened that changed everything and caused this hospital to come away with the idea that they had to prove that Maya did not have CRPS, she didn't have pain, and do everything they possibly could to try to convince her, a 10-year-old girl, 11-year-old girl, that she wasn't feeling what she was feeling, and to put the maximum amount of pressure on Beata. What would do this? So, leading up to this, one of the things they talk about are the amazing number of infusions. And I want to point out something else. I'm jumping around here a little bit. One of their big reasons for needing to keep Maya there was withdrawal, that somehow ketamine was like an opiate and you had to keep her there to wean her off, or she would be physiologically harmed in some way, right? Take a look at the number of times that she had an infusion, which are in green, and all the red are the periods between those infusions. And if you look at the medical records, nothing in those records ever shows a single sign of any withdrawal. There's no shaking and there's no runny nose or jitters. There's no raised blood pressure for no apparent reason. There's nothing to indicate that this child's having withdrawal symptoms. The proof is in the pudding. I don't know why they brought the addictionologist in here, Dr. Levy, because she simply did not understand the disease, and her statements were so far afield, and she absolutely could not explain why Maya was able to get through all these, stop from anywhere from a day up to 37 days, and never have the single sign of withdrawal. And the reason was there are no withdrawals from ketamine. There aren't any. There was no reason to keep her there. There was no reason to keep her in the hospital. Maya should have been in and out, right? Right. So on this January 7th, Beata shows up to support her daughter. And you know what? I don't know what went on with Maya in terms of whether she was using bad language, and I don't care, because nowhere in this record before or after is there any sign whatsoever of her having done anything even remotely like that. And you've spent 8 weeks around her, and ask yourself, is she really the type to do that? Keep in mind also, though, she'd had a steroid course for a significant period of time before this. You ever heard roid rage? And there was no paneling when she went in to figure out what she was on. And then she was put back on a bunch of narcotics. But it doesn't really matter because they weren't looking at the history. Something happened back there between Beata Kowalski and that team, who I still can't figure out. I think it was Tepa Sanchez. I think that Dr. Malik was back there. Some nurses. But something happened back there that ticked them off. They got...
I'm sorry?
Are we approach?
Objections overruled. You may continue, Mr. Anderson.
All right. So back there, I'm not sure who said what, but I'm pretty sure with Beata's personality that what she did was start to question them and say, we were just here 6 days ago, and by the way, we've been coming here. You're supposed to be our hospital. You're supposed to be our doctors. Why are you putting us through this? Why are you questioning everything that I say here? I don't want Maya to have a blood pressure cuff because do you understand about allodynia? Do you understand about how this disease is? I've been coming here for forever. Why don't you people pick up on this? And that ticked them off because she was challenging them. And there must have been some words back and forth because somehow, somewhere, they decided to completely change over the diagnoses. And whether they did it immediately in the record or whether they simply did it in every way they approached everything and everybody that they told outside of the hospital, there's no question that they tried to change the narrative here. And walking in as a normal family with a child with a debilitating disease, they walked out suddenly with Beata as the enemy and Maya as a liar. That Maya was making all of this up and that Beata was somehow encouraging it. So, whatever happened, and I'm pretty sure it was that Beata started to ask people's names. And she started to take down those names and she started to ask very, very pointed questions. Because remember, within the first 24 hours they were there, they called risk management. Within 24 hours, with the patient they'd had for a year and a half, they called risk management. Something else very interesting here. Remember one of my first witnesses, Debbie Hanna? She was the social worker that was brought in, and it wasn't her regular gig, but she was brought in to help on this. And she sat down with the Kowalskis, and she said that they were like every other family with a child that was in a lot of pain and with a desperate disease. They were incredibly concerned. But she didn't see any signs whatsoever of abnormal behavior. And this is the social worker. This is the one that's supposed to pick up on stuff like this. And there's another thing I want you to keep in the back of your mind. She was never allowed and never did finish her psychosocial evaluation, which is what you put together to see whether there are any psychosocial problems. Are there any psychiatric issues going on here? Is there something going on that maybe we didn't spot over the past 15 months and 50 doctors? She was not allowed to complete that, and risk management took over. It's very strange, very strange. After that, what did we see? We saw Sally Smith brought in. What the heck was Sally Smith doing there? Why were they bringing her in? Why did they have her checking records on October 8th, the next day, without the Kowalskis' authority, by the way, and without their consent and without their knowledge? Why was she going in there and looking back at all these records? What was her role here? Sally Smith eventually comes in to see them, and she doesn't identify herself as Sally Smith. Whatever she's trying to say up there, you know she came in a lab coat, and she came in with her doctor's pass. You know she walked in, and she started to try to get information from them without identifying herself. She was trying to set up a case or some complaint or something. She was the hammer. She was the hammer that they might need down the road. Should the Kowalskis come back, make any complaints? Remember, this was a place where if a person complained, there was retribution. Dr. Corcoran? If a person complained, then there was a chance they could lose their jobs. Nobody was complaining up and down, and no one wanted to hear any complaints about them. And here was Beata taking down names. They panicked, and they decided they weren't going to let this brusque lady with an Eastern European accent coming in and telling them how to do their job and what they could do and not do and what tests they could do and not do, right? They got really, really upset at being bossed around by this lady. And she was a nurse too, which made it even worse. By the way, why are they so worked up about Beata Kowalski, an infusion nurse, giving her child infusions? I never made the connection there as to what that's supposed to signify to anyone. So after that, you can see here, well, beforehand, you can see the times leading up to it. After this, there's a psychological evaluation on January 6, 2017 by Dr. Duncan. You got that back there, there's no problem found. They bring in Dr. Lewis, who was working for the state. He was not one of their doctors, he was working for the state. You gotta look beyond what you're being told to see what was really going on here. Dr. Lewis, whatever Maya's saying, he's putting down what he wants to say to try to support a narrative. But even he can't bring himself to say that this is psychosomatic. He says you got to get a pediatric neurologist to look at this to confirm whether or not there's a physiological basis, right? So Sally Smith is in here, and all of a sudden Sally Smith starts running the show. She was an apparent agent. Under the definition that you're going to get, I want you to check yes on apparent agent if you agree that we've proven through the testimony of Elena Kushner, who also, amazingly enough, had an Eastern European accent, and also had the same experience of Sally Smith coming in a white lab coat and starting to ask questions. No introduction. No, hi, I'm Dr. Smith. I'm here to help you. What can I do? Anything like that. No, probing questions to try to see what could be uncovered. The Kowalskis became the enemies. The Kowalskis had become the enemies, right? And remember, this was a hospital that was under immediate jeopardy of losing its license, right? These people were worked up, and they didn't want anybody rocking the boat. But in any event, they talk the Kowalskis into staying. They tell them, we're going to help here, we're going to help there. And Beata says, no, we're going to go back, like we did on the first, to Dr. Hannah, and we're going to complete the ketamine infusions because you guys can't help us. No doubt Beata brought her in to see if there could be an intubation and greater amounts of ketamine to try to get her out of this crisis. And when they couldn't do it, she concluded, why are we here? And tried to leave. And she was told, well, if you leave, then you're AMA and we're going to call security. And that's in the records. So they were forced to stay. And as much as they try to dig around in the records, ask yourself, do you believe they really wanted to stay in that hospital when there was no reason to do so? Maya was not getting the care she wanted and the care that the parents wanted. You know, there's a lot of people watching this. There's a lot of people looking at this. There are CRPS patients. There are parents who have children in crisis trying to figure out what to do. There's a lot of people who are paying attention to what you're doing here. And in this instance,
Objection is sustained.
Thank you.
and it's important here to consider what was going on behind the scenes. So through the course of the time from October 7th up until the 13th, when this order was obtained, they desperately wanted to get out of that place, but were not allowed out of this place, although they tried to talk them into. Johns Hopkins did their best to try to convince the Kowalskis that, well, she's got withdrawal symptoms, she'll have withdrawal symptoms, we need to wean her down, everything you've been doing is wrong. And you know what? The Kowalskis were at least listening to them. They didn't buy it, but they were at least listening to them. They weren't uncooperative about this, but all they wanted to do was get out of there and get someplace where Maya could be properly treated. That's the reason they came in. They had no reason to stay there. They didn't want Maya under this hospital's care if the hospital couldn't do anything more for them. That's called false imprisonment. And that's where you would check yes on that particular one. I'm skipping around here, but in your verdict form, it's interesting. You've got different events listed, okay? And you're going to be asked individual questions about individual events. And so this is one of them. Another one is when when Kathy Beatty and company pinned her down on January 6th. That's another one. Right. He's right. I need to talk about the suicide. I'm interested here in the circumstances living up to Beata. You know, her motto was live with passion, right? And she had everything in the world to live with, live for. And she died with the same passion. Consider the fact that she came from a communist country and saw her father dragged out of the house by the powers that be, right? Beata Kowalski gave her life for her child because she knew Beata was prescient. She knew something was going on in that hospital, and she had been told repeatedly about how her daughter was suffering. And she knew enough to just listen to her daughter. And you heard the phone calls to know what was going on. And every time somebody saw her daughter, any of the neighbors that got in, any of the priest, anyone else who got in, she was pumping them for information. She knew exactly what was going on here. And so as Maya started to get worse and worse and worse, the anxiety of Beata went up and up and up until it came about finally that Beata determined unless something drastic was done, there's a pretty good chance her daughter was going to die in this hospital. Why? She'd already seen a friend's daughter die from CRPS. CRPS can kill you. And in this instance, where you've got someone who is becoming so weak that they're laying down and they can't even hold themselves up, you're subject to blood clots that can go to the heart and kill. And that's what Beata was concerned about. There was retaliation against me because they knew I was going after the ICU. Filing charges with me with DCF automatically makes them automatically immune. But what it says here is that Beata knew what was going on with her daughter and knew she had to do something drastic. She knew they were retaliating against her. She knew that she was the key. If she was in the picture, Maya was never going to get out of there. And it was likely that Maya was going to end up in some kind of foster care and in some situation where she would be even worse.
Objection.
That's in the
Legal basis?
The legal basis is the immunity. We're not responsible for.
No, I've already instructed the jury on that.
Okay.
She knew if she did not take herself out of the picture, that it was likely, it was a probability that her daughter would die. The best hope would be that her daughter lived, but was with some foster parents who did not understand the disease, or was placed in a situation where she was going to be in psychiatric care. And the rest of her life, Beata knew, because she was a nurse, that Maya would be followed through her entire life, dogged by these allegations that somehow there was a psychosis going on. Afterwards, Dr. Tepa Sanchez writes and says, she's talking to Dr. Laura Vos at this time, I learned today that Ketamine Girl's mom committed suicide yesterday. Sorry to say my prediction was correct. That means it had happened before. They knew about it, and yet they still kept the pressure on. They still kept the pressure on Beata. Oh my God. they still thought somehow this was the right thing to push Beata to the edge and over. They knew she was on the edge, and they kept up the pressure. There's no question but that this suicide was caused directly by their actions. On the verdict form, what you're going to see is a few things, but one of them is there's two bases, and you heard Dr. Richards testify about both of them. One is, was it a substantial factor? Were their actions a substantial factor in the suicide? I submit, absolutely. The second was, did she operate from an irresistible impulse? The irresistible impulse in this instance was the maternal instinct. There was nothing she could do about it. She knew if she didn't protect her daughter here, she was going to lose her daughter. And Beata knew also, she thought through the effect of her being out of the picture. She knew it'd be tough on Kyle. She knew it'd be tough on Maya and Jack. But she figured having Maya alive was better than losing Maya. She knew they could get through somehow. But she could not stand the thought of losing her baby girl. Please take care of Maya. Don't make her suffer anymore. She doesn't deserve that. No child deserves that. Insofar as the verdict on suicide, I request that you check, yes, it was caused by them. And it's important, very important, that you answer questions 45, 46, 47, 48, and 55 in the positive, if you want a recovery for Jack and for Kyle. These are the causes of action for wrongful death, and they are allowed to recover based on being beneficiaries of the estate. So that if you want to award damages to Jack for the loss of his wife and to Kyle for the loss of his mother, then you have to determine that there was an intentional infliction of emotional distress. And under that definition, by any definition, this was emotional distress that was absolutely outrageous. You just don't do what they did to a little girl like this. You just don't take away a gift. You don't tell her that her mother's crazy. You don't tell her that her mother is in a mental institution. You don't pat her, and you know what? They were patting her. Beatty would come in and pat her on the way in and way out. She was trying to develop evidence so that she could say, oh, she never reacted to that. She must not have had allodynia. That's why she was doing it. You don't put a child on your lap. You do not cuddle with a child, and you sure don't kiss a child. There was no authorization whatsoever, and Maya loathed Kathy Beatty. Remember the attorney, Zimmerman, who said it came off in waves how much she disliked Kathy Beatty. Maya did not consent to anything, and what they did was continue to put the pressure on all the way through this. So let me talk a little bit about your verdict form. There's so much to talk about in these cases, it's easy to get bogged down on it. Under false imprisonment, your claim 1, I submit there's more than enough evidence to show that they were falsely imprisoned. Maya was falsely imprisoned on the occasion of October 7th through October 13th. And then you're asked to put down damages for her pain and suffering and for mental and psychological expenses and the reasonable value of hospitalization. And that question is repeated several times through this on each one of the first two claims. What I suggest you do in trying to determine exactly how much to award is that you make a determination of the gross amount of pain and suffering, loss of capacity to enjoy life, mental anguish, and you determine the big picture, because you're going to have to determine that for intentional infliction of emotional distress and malpractice, okay? And then you go back and you assign a percentage of that to each one of these events, because each one of the events are set out separately, and you're supposed to award damages separately. Now you have in your records there, you've got the $10 million plus for Dr. Bifulco's plan, for his life care plan. And that then is spread out among the first two based on the percentages that you see are the most severe. If you determine, for instance, that the January 6, 2017 incident, where she was stripped, pinned down, photographed against her will, if you determine that that one is one of the most severe, you would put the highest percentage for it. So do the math first. Figure out, and Nick's going to give you some ideas about this. Figure out using and we've got the formula in there. Figure out the number of days that she was down. Remember how we had them fill out all of these forms to tell you how many days per week that this was really affecting them? And then you need to talk among yourselves and figure out an hourly rate. Now, we use hourly rates for a lot of different things in our lives. And this is the best way we have come up with for you to measure what happened to them. So you would take the hourly rate that you determine, and Nick's going to go over the remainder of it, but you're going to multiply it out against the amount of years left, which will give you the amount of days. I'll let him talk about it. But then what we want you to do is come back and give a percentage as to each one of the events. And that way you'll be able to capture all of them. And there's an instruction there about don't duplicate. This is a good way of making sure that that does not happen. Is if you use it by percentages after determining the entire amount of pain and suffering, loss of capacity to enjoy life, and mental anguish. So you have a series of questions in your first few pages about false imprisonment, and you'll be asked about how to give the numbers for each one of those. Then you've got battery, and it is the battery for the psychological, whether they committed battery on Maya Kowalski on January 6th. I think everyone here agrees from the testimony that Maya was battered. And then, like I said, you have separate questions there, right, for the damages. Then it's the second one on claim 2, battery, hugs, kiss, and pats. In this instance, we're talking about the instances where Kathy Beatty is hugging her, patting her, kissing her, putting her on the lap, but it's broader than that. You just can't be duplicative. That's why I say come up with the percentage after you determine the total. And then there are claims for the total. And it's important that you emphasize the damages for these two to begin with, because they are what we call core events. They are the batteries and the false imprisonments and the things done to them, out of which many of the other causes of action, particularly intentional infliction of emotional distress, which is your big picture one, will be based. So if you're going to award damages, economic damages, they need to be heavily weighted towards the first two causes of action, battery and false imprisonment. Then you get to medical malpractice. In this instance, you heard testimony from Dr. Chopra. You heard testimony from Dr. Eli Neuberger that they deviated from the accepted standard of care. And you'll be asked then, again, to divide out damages for that medical malpractice. But again, that's a much bigger picture. On moving to and you have to, by the way, on medical malpractice, you have to go through the conduct of Sally Smith. And for Sally Smith, here's what you need to consider. Sally Smith shouldn't have even been there, but she was an apparent agent. An apparent agent is someone who presents themselves as though they are part of the hospital. You know she did, and there's backup testimony to that. But she's in there, and they're responsible for her. But Sally Smith was telling them to take her all the way off medication, telling them to put her in the room for 48 hours. Those doctors are also responsible because they should have rejected that. They should have said, what are we doing here? By the way, one of the defenses they're going to talk about is, oh, this is all medically authorized because they signed a medical authorization at the start. That's if it was medical. This was not medical. And you haven't heard any evidence of any discussions that it was medical. If you look at the records before and after these dates, the October 18th, 19th, 48 hours, look before and after that. No medical discussion whatsoever. This wasn't for medicine. This was for the purposes of developing evidence against them. If you look again in the January 6th, the Kathy Beatty incident with the photographs, the idea was, well, they're authorized to take the photographs only if it was for a medical reason. This wasn't a medical reason. They did not discuss it before or afterwards. This was not for the reason of trying to diagnose or treat Maya. This was to help them for their other goal in this case, was to frankly take things out on the Kowalskis. On fraudulent billing, claim 4. This has to do with the amount of money that was billed for CRPS when they denied in everything else that she had CRPS. Now they're going to try to mix that in here. Don't let them. The CRPS, in every way outside of that billing, they did not treat it as CRPS. And they represented to the outside world that it was not CRPS. And if you go to the discharge summary, you'll see CRPS is not listed. So what they did is they billed for a bunch of stuff that they actually did not do. They weren't treating her for CRPS. They weren't doing the things you need to do. Keep in mind that Katzenstein, Dr. Katzenstein, only gave her 5 hours of therapy through the course of 97 days. Got it. And so checking yes to that, and then as to the damages on this, for various reasons, these are going to be what are known as nominal damages and taken care of later. So these are going to be, if you review the facts and you see the evidence involving any increase in insurance or any copays, you can put that down. If you cannot find specifics on that, you may put $1 as a nominal damage, and that'll be taken care of later. Then we get to count 5, survivor claim for intentional infliction of emotional distress for the estate of Beata Kowalski. This is the manner in which you can compensate Beata and the rest of her family for her loss. If you check yes, then they can be. If you check no, they cannot be. And then you determine, as the best you can, her pain and suffering, mental anguish, and extreme caused by the extreme emotional distress prior to her death. Nick will talk a little bit about this. Claim 6 on the estate. Again, they're going to go through whether or not this was an uncontrollable impulse to die by suicide. We suggest you check yes. And whether it was a substantial factor, it was too, and that you check yes. And of course, the top 136, did Johns Hopkins Hospital, through the acts of the employees, engage in extreme and outrageous conduct? Yes. And then you get into the damages. Now, you've seen the report. The net accumulations are the amount of money that Beata would have made and they would have had for the family, deducting from that their living expenses, which Christy Kirby has already done for you, and it's in her report. And then it's the damages of the surviving spouse, Jack Kowalski. And here, again, we suggest that you use our method for how to compute damages, which is to figure out for hour by hour what the value is for him to have lost his wife. Everything that goes into that. The consortium, the comfort, the support, the waking up at 4 a.m., and having somebody next to you, and then not having somebody next to you. All of those goes into your determination of how to compensate. Jack Kowalski. And so what you would do there, and I'm suggesting $100, but there is evidence in the record for this, anywhere from minimum wage, which is like $12, up to, there's evidence in the record of $700 per hour. We put 100 in just to give you an idea, but you can go twice that, 3 times that. Whatever you determine as jurors is the best way to express the loss here to these folks. And so you go through the amount there, and then you get to go finally to the survival damages of Kyle Kowalski. We haven't talked about Kyle a lot here, but he lost his mother, and he's not going to have his mother there for many of the events in his life. She's not going to be there if he gets married. She's not going to be there to send him off to college. She's not going to be there to comfort and support him as he gets out in the real world. There really is no way to adequately compensate him. And the only thing we can do here is dollars. That's the way we do it in the United States, because it's the only way we can show. And remember, this is not a reward. You're not rewarding these people. It's an award, trying to measure their loss. You're trying to express the loss. And then the intentional infliction of emotional distress of Maya Kowalski. All right. Maya lost her mother. I don't even know how to begin to describe that. Maya will be affected the rest of her life. You have life tables that will tell you how long Beata would have lived and been in her life. She will not be there to help Maya pick out her bridal gown if she ever decides that she wants to get married. She will not be there when the stresses and strains of life are there. She will not be there at the other end of the line to pick up the phone and talk to. She is not going to be there when Maya needs her most. And for that, you have to find out. You have to look at the evidence and use your own life experiences to determine what that value is. And again, I suggest you look at it by the hour, and then you go back and you multiply that by the number of hours per day and the number of days per year against the total life of Beata Kowalski. That means the amount of time in Maya's life. Then you sign and date the verdict form. There is so much to talk about in this case. I haven't spent as much time on liability as I'd like to, let alone about Kathy Beatty. Beatty had mental problems. There was something very wrong with her. And when you say, as she said in one of those statements there, when she was brought up for her behavior, you want to take this outside. What does that mean? That means she's trying to pick a fist fight with the other employee. That was on November 20th, 22nd of 2016. Was it really logical and reasonable to have somebody with that type of personality assigned to Maya? And why did Maya need somebody assigned to her to begin with? Why did you have somebody follow her around all the time, floor to floor? What was going on there? They had a plan. And the plan was to force Maya to agree with them that she really didn't have pain, and force Beata to take some action that would make her even more vulnerable. We don't know how. Now we know how she acted out. But they were hoping for some outrageous action out of Beata that would give them even more power over the situation. And I submit to you that Beatty wanted Maya for her own.
Mr. Anderson, you have consumed 1 hour.
I'll come back and talk to you a little more. I'm going to let Nick talk for just a second on some numbers. And then the other side gets a chance to talk, and I'll be back to talk to you. With that.
So last time I had to do this, he gave me a whiteboard and I sat right there and had to scribble it out. And this time he gave me about 12 hours notice. So it's time to do some math. And now he's left me 10 minutes to do it with you. So here we go. I'm here to give you, it's a difficult task to decide what justice is here for the Kowalski family. So I'm here to give you some formulas using that $100 an hour figure based on the testimony of Maya and Kyle and Jack. And I'm going to put some big numbers in front of you. That's what justice requires here. So we'll start. First, I want to take a look at the verdict form, claim 2, battery, which is page 8. And I'm looking at question 18. Now, January 6, 2017, you have conclusive, uncontested evidence in the record that on that date, there was a battery of Maya, and over her objection and tears, Catherine Beatty admitted that unfortunately they went ahead and did it at the direction of risk management. And question 18 is where you award damages for each of these categories. That's why I'm focusing on each of these, you make separate calculations. Pain and suffering is its own. Mental anguish is its own. Loss of capacity for the enjoyment of life is its own category. And each of them are going to be calculated for the past and future. And I recognize some of you probably have mathematical skills better than the others. So I'd ask you to lean on those folks as you're back there with a calculator trying to figure this out and do what you need to do to deliver justice. So let's go through some examples of how you would calculate for each of these categories. If you pull up slide 57 to begin. This bucket of different categories I've just described here and pointed out to you, we've called them human damages. And so we're going to talk through not all of them because you have to do this for each claim. There are 2 separate battery claims. There are 3 separate false imprisonment claims. There's intentional infliction of emotional distress for Maya. There's medical malpractice. For each of these, you have to do this calculation. And then as Mr. Anderson was saying, once you come up with your total figure, then you decide, this PTSD and what Maya's suffering with, 50% of this was due to, and it really focused on this battery on January 6th. I don't know. That's your job. That's your job to allocate once you have this final number. If we go to slide 59, please. I'm going to show you the first calculation here. All right. Maya Kowalski testified that she experiences and has experienced mental anguish 15 hours a day on average if you take a good week and a bad week. Since this horrific saga ended at Johns Hopkins Children's Hospital, it's been 6.82 years. You can check our math on that. That's to the day since she was discharged. And if you apply the rate of $100 an hour to her past mental anguish, you get to this figure of $3.7 million. That's the past figure. That's the past mental anguish. Mental anguish is one of the categories under battery for the question 18. Now we have to do the same thing for the future. And you'll have the life care tables back there with you. They're at the mortality tables. Exhibit 2060, there's page 002, and there's pages 47 to 50. So you can check that our economist, when she came in here, and what we're representing to you is Maya's life expectancy from those mortality tables. So we do the same math. We take the hours per day that Maya experiences mental anguish. We take the days per year. We take the years remaining in Maya's life, and we multiply that by $100. And you get a figure of $34.8 million for Maya's mental anguish. And if you go advance one more here, you'll get a total for her past and future mental anguish. Then you allocate that among the different claims. If you'll back up to slide 55, please. We have, in addition to the human damages, we have economic damages. And these are directly from the testimony of Christy Kirby, the economist, and the life care plan. This is when I was writing on the whiteboard over here. If you go to slide 56, this is the essence of what Christy Kirby told you. At a wage or an annual earnings of approximately $100,000, which we would submit to you underestimates Maya's potential before this all happened to her. The loss of earning capacity is $5 million. And then you have future medical expenses, and this was based on the testimony of Dr. Bafolko, and then Christy Kirby coming in and giving you the present value calculation. $10 million. So now you have economic damages to Maya Kowalski of $15 million. And you'll see this ability to compensate Maya Kowalski for her future medical needs and her future loss of earning capacity in several different places. For example, you'll see the ability to compensate her for future medical expenses in question 17 on the verdict form. Then I need to go to the verdict form for just a moment to look at question 34 and 36. And Mr. Anderson discussed this for a moment, but to unlock your ability to compensate and deliver justice, not just to Maya, but to Beata and Jack and Kyle, you need to answer yes on question 34. That Johns Hopkins All Children's Hospital, through its extreme and outrageous conduct, inflicted severe emotional distress on Beata, even before her death. You need to answer yes to that question, and then you'll advance to question 36 on the next page. And question 36, you need to answer yes. And if you answer questions 34 and 36 yes, then you have the opportunity to do justice for Jack and Kyle and Beata. If you answer no to those questions, 34 and 36, you'll only be compensating Maya. Having checked yes on questions 34 and 36, now we have to discuss what the wrongful death damages. So if we go to slide 63, please. We're going to talk first about Beata's loss, what's called loss of net accumulations. And this is just legal jargon for if Beata had survived this onslaught, how much would she have earned through her wages as of the time of her death in 2016, adjusted for inflation, adjusted back for present value. This is the number Christy Kirby gave you, $653,000. Then we go to Jack's wrongful death damages, slide 64. There are two categories here, and I'm going to direct you to the jury questions, which are at 40 and 41. If we could put those up for just a moment. Sorry to switch back and forth on you here. All right, right there. Questions 40 and 41. The damages for Jack Kowalski for the loss of Beata. He has two primary categories. The first is the loss of her support and services. This was, again, a number that Christy Kirby calculated for you based on something like a wage of $20 an hour for her helping to get the kids to figure skating or taking them fishing or doing laundry or cooking, those types of things. And that number I'll show you in a moment. I also want to show you that under 41, you get to compensate Jack Kowalski for the loss of Beata's companionship, what Mr. Anderson was just referencing about not being able to wake up next to his wife. So if we go back to slide 65. as I mentioned, Christy Kirby did the math. I said $20 an hour is $20.10 in the past, $24.87 in the future. Total services lost by Mr. Kowalski due to Beata essentially being a good spouse and helping him around the house, $801,000. That's fairly simple. Next slide, loss of Beata's companionship. Now we get into calculations that are similar to what we did with Maya for her human damages. Jack has shorter life expectancy. We're using the same $100 figure. So the numbers are a little bit lower for Jack because fortunately he doesn't have as long to live. So if we show here the past calculation, he testified again to 14 hours a day. We get $3.4 million for losing Beata's companionship. And then if we go to the future, and again, this is based on the mortality table, in advance, 19.4 years remaining in his life expectancy, and we get a figure of $9 million for his future loss of Beata's companionship for a total of $13,398,000. Again, the $100 figure is up to you. The hours per day is up to you. You judge the credibility of the Kowalski family, and you go back and you look at your notes as to what they testified to hours per day, and you arrive at the appropriate number. You have to do the same thing. I'm not going to show you another calculation, but in question 41, loss of his wife's companionship is one category. Pain and suffering is a separate category. So you would do a similar calculation for Jack's pain and suffering. Let's advance to slide 68. Having done those calculations at $100 an hour, this is the figure we suggest to you for Jack's wrongful death damages, $26 million. Now I'm going to show you how to do similar calculations for Kyle under the wrongful death claims, which would mirror what you would do for Maya. So if we go to slide 73, and then 74. Now, each of Maya and Kyle have, it's not the loss of just companionship, it's the loss of parental companionship, guidance, and instruction. It's not having their mom around to bake with or take them to figure skating or help them with their homework, teach them piano. This is what Kyle testified to. Kyle's a little more stoic, quiet. He testified to 8 hours per day. So we do the same calculation for the past in much the same manner we did it for Maya Kowalski. And for loss of parental companionship, we get to $2 million in the past, and in the future, over his life expectancy, not having a mom and thinking about those 3 months for the rest of his life, and that day that he saw his mom in the garage. $17 million. And then total for Kyle Kowalski, and this is your only opportunity to compensate Kyle Kowalski in this lawsuit, $19 million. So, and then we could advance to slide 77. I'm sorry, 76, please, if you could. Is this 76? All right. Having performed those calculations for the two categories available to Kyle in this lawsuit, we submit $36 million is a starting point at $100 an hour. Next slide, please. And then we would total up the wrongful death damages. And you know what? I'm going to skip these. Go to slide 78, please. Having used this construct, used this math, used the $100 an hour we suggested, and checking yes on the appropriate questions, you would arrive at a figure of $238 million. We're not here to tell you that's the number you need to put up. We're here to tell you that that's at $100 an hour. there's a movie called Onward. The basic plot is it's an animated Pixar film. I have kids 10 and 7 myself, so I watch more of these films than I hope to. Two boys lost their father, and they spend the movie attempting to bring back their father for a moment through magic and spells and a treasure hunt, and at the end they're successful. The $100 an hour figure we submit to you, if any of these three had an opportunity to pay $100 for an hour with their mom or their wife, they would do it. They'd pay $1,000 an hour. We don't think $100 an hour is appropriate. We ask you to deliver justice for the Kowalskis.
Are the plaintiffs at this point concluding their first part of their closing argument? Mr. Anderson, Mr. Whitney?
Sir,
Are you concluding your first part of your closing arguments?
I think we're out of time.
Okay, members of the jury, we are going to take a 10-minute break. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Your next chunk of time is going to be about 2 hours. So if you need to use the restroom, I would highly encourage your use of it at this time. The jury's out of our presence. Any issues we need to address before we take our break?
No, Your Honor.
Let's keep this to 10 minutes. We need to keep this going today. 10 minutes.
All rise, this court is in recess.
Let's get this set up. Let's think. Yeah, here, try it. Got everything? Yep. Yeah. Sorry for blocking a bit. Okay. Yeah.
Just, I'll start it for you, but. If you need, it doesn't, just go ahead. Okay. That is your blank screen.
Okay.
And then.
Gotcha. Okay.
What's the final decision on this?
Yes, thank you.
Yes.
The judge is going to see the jurors, though. That's not going to work. You know, I'm going to lower this. Hey, David. David. You want to help me with this? You're going to be secretary.
All rise, this court is in session.
Okay, please be seated, everybody. Ooh.
Yeah, I'm going to lower these to that one.
Do you have anything that you can put it here in the witness stand area, since obviously we don't have a witness? Just
Let me just see how this works, if it's more height.
all right, well, you want to use that area, that's fine too. It's up to you. But I just need to be able to see the jurors.
I realize that. I realize that.
Can you raise those? Just to like a couple inches?
Yep.
Do we, I mean, the jury's not here, so you need to approach even though the jury's not here? Okay. I suspect I would need Mr. Anderson and Mr. Whitney and Miss Lawrence if she's coming. I understand that a lot of you have very strong views each way, and I totally get that, and I appreciate that, and no one is going to fault you for having whatever views you may have. What I cannot have happen, though, is you all accosting each other or somehow taking out your views on the other people. So let's please remain respectful of everyone's views. This is a place of safety, and I don't want us to change that. We've had a really, really good run for these 9 weeks, and I don't want to change that. So please just respect everybody's views. I know that each side has very strong views, but please keep them to yourself, or if you need to exercise your First Amendment, we do have an area that you can go right outside of the courthouse that is right in the view of the courthouse. If you wish to express your First Amendment rights, I would invite you to do that. But please, you can't take it out here in the courtroom or in the hallway outside the courtroom. So with that, I think that's sufficient at this time. Anything else we need to address before we bring in the jury?
No, Your Honor.
Mr. Anderson, anything else before we bring in the jury?
No, Your Honor.
Let's bring in the jury. Everyone, please be seated. Members of the jury, I just want to confirm while you're away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information. Okay. I also want to confirm that no one approached you about this case. Is that correct? And you have not seen any media coverage about this case. Is that correct? Mr. Shapiro, you have the floor, sir.
And may it please the court. Good morning. I wanted to start with a couple thank yous, if you'll indulge me. I want to thank the court for conducting this trial in a civil manner. This is a civil justice system, and I think it's a testament to that. I wanted to thank Deputy DeMizio and Deputy Coley for keeping this courtroom safe and helping you through the process. I'd like to thank the Kowalskis for listening patiently and respectfully. I know that a lot of the things I've had to say have been tough for them to listen, but they've listened with grace and integrity, and I thank them for that. I'd like to thank my trial team sitting behind me, too numerous to name, but we've all been here. I'd like to thank you from the bottom of my heart for your service. This has been a long 9 weeks. Indeed, we started in the summer. But you've listened patiently. You've asked great questions throughout the process, and we appreciate your active engagement. But most importantly, I want to thank these people, the people of All Children's Hospital, and they've given me the privilege of standing before you to be able to tell their story. And that's what I plan to do during my time. They want you to know that All Children's did not harm this family. Not just the people here, but the people back working at the hospital. They want you to know that. We are here because we believe on behalf of the hospital practiced safe, evidence-based medicine, and we're here to defend the hospital's right to practice that medicine. And I've put up a list here of the witnesses because you've heard from a lot of people, so when we talk about witnesses, if this helps orient you to who's who, this on this side is who I represent. On the other side are people you've heard from that I do not represent and who we are not responsible for. It's almost Thanksgiving, so I put up the pie. And I don't know if this is an interesting memory, but way back when we did jury selection, you may remember we had a little bit of fun. We talked about pie and what your favorite pie was, and I've learned that some people don't like pumpkin pie, which is incredible to me, but that will be an interesting topic at Thanksgiving. But the reason why we had that moment was because there was an incredibly important question that followed it. Can you judge this case fairly based on the evidence? Can you hold the plaintiffs to their burden? They have the burden to prove the claims. And in fairness, Mr. Anderson and Mr. Whitney have welcomed that burden. And most importantly, can you reach your decision here based on the facts and the law and not on sympathy? And that's important because this is a sympathetic case. Nobody is denying that this is a sympathetic case. In fact, if you didn't feel sympathy in your heart, you wouldn't be human. But the judge has instructed you, and everyone here took an oath, to make sure that their verdict is reached on the law and the evidence and not on sympathy. In order to know how we got to All Children's, we need to take a little bit of a step back, and I think it's going to be very helpful if I can walk you through the treatment and what happened leading up to All Children's, because it was almost like a Quentin Tarantino movie where you saw a bit of the end, then a bit of the middle, then something in the middle, then something at the end. And what I intend to do with you is walk you through. And actually, the case begins before the 4th of July. You heard from Dr. Wyndham in his deposition testimony. He spoke fast, but these records are in evidence. And by the way, if you look in the lower right-hand corner, if there's a document you want to see in the jury room, I've tried to reference every single one. So, for example, this would be Defense Exhibit 3050, 1 through 4, if that helps you, if it's something you want to see on your own. Before the 4th of July, before the incident, the Kowalskis went to Dr. Wyndham with the cough that you heard the audio of, and Dr. Wyndham said there's nothing that I can see wrong with the lungs. The pulse ox is normal. And he says something really is not right. This is not just asthma. He advised the Kowalskis to watch the steroid use and noted at the end that the parents were arguing about taking her to the emergency department and question the role of family dynamics. We know from this picture that on July 3rd, Maya and her brother were participating, healthy and normal, in the local July 4th parade. We also learned about CRPS. We learned a lot about CRPS. We learned from almost every expert here that it starts with an injury. But what we saw when the Kowalskis presented to the Sarasota Memorial Emergency Department, that the onset of this was getting worked up about the 4th of July, and when the fireworks began going off, there was some trouble with breathing. We know in the note that Beata Kowalski gave the prednisone, and IM, intramuscular, a shot of Benadryl with no resolve. And then even at this very first visit, this emergency doctor, Dr. Brett Williams, noted his concern of a potential psych component. Let me orient you to the several presentations of the All Children's Emergency Department. The first one was July 6th to July 11th. And by this point, Maya had presented in a wheelchair, less than 72 hours after the initial onset. Of significance, she was seen by a pediatric neurologist. Very early on in the presentation, Dr. Joseph Casadante of the All Children's Pediatric Neurology Service wrote that this was an unusual presentation. It's associated with what he believed was a habit cough, putting his impression in agreement with Dr. Wyndham. Physical therapy was consulted because of the presentation in a wheelchair. And at this point, we start to see what starts to appear more and more in the records, which is that Maya, patient, wants to make sure therapy stops, physical therapy, occupational therapy stops when she says so, and that, according to mom, Maya needs more pain medication. Maya was discharged from this hospitalization on July 10th, and the initial diagnosis was chronic steroid use and a habit cough. Less than a week later, Maya comes back with her family to All Children's. Now we're on July 17th to 20th, 2015, so this is still more than a year before she comes to All Children's. And when this is an important piece of information. This is from Joint Exhibit 100854. When the plaintiff said to you in their case, nobody at All Children's ever suspected conversion disorder or somatization, remember, he said that to you, prior to October 2016, it's right here from Dr. Kilgore. In the history and physical from July 17th, 2015, her differential diagnosis included psychological pain, conversion disorder, and somatization. And it's important because in opening argument, you may remember the plaintiff told you that at the end of this admission, this is right before they go to Lurie's, the doctors threw up their hands and said, Mr. Kowalski, we have no idea what's going on. The record says otherwise. The record says even at this early date back in July of 2017, the differential diagnosis of a psychological pain conversion disorder was in their records. Now, again, conversion disorder does not mean that Maya's not feeling real pain. Let's make that very clear. But there's a psychological component to this that does not require ketamine, and we'll talk about that. Now, what we unfortunately start to see a pattern of is what the defense would respectfully suggest is a history of unnecessary medications given at dangerous doses. Unnecessary medications that are given at dangerous doses. And it started back at this admission on July 20th, 2015. And it started when the discharging nurse noted Mrs. Kowalski was adamant that they would need a PICC line, peripheral inserted central catheter for transfer, but the All Children's team warned that doing that with a commercial flight was both inappropriate and dangerous. The Kowalskis made their way to Lurie Children's Hospital. For a second opinion, totally appropriate. They're going back to their trusted children's hospital in Chicago. World-class hospital. And we heard from the emergency department physician, Dr. Petzenberger, that upon his first visit with Maya in the emergency department, Maya was able to show good upper and lower extremity strength by kicking with both legs. And now his diagnosis is fitting that of Dr. Kilgore, that the behaviors were concerning for a psychiatric component, possible conversion disorder. And again, this is not a question of somebody saying that Maya is faking it. This is real, but it calls for a different treatment pattern. Now, a lot of what you heard during cross-examination was, are you an expert in CRPS? You remember this. Every doctor, are you an expert in CRS? Well, they met one, and you heard from him. Dr. Gatti Revivo from Lurie Children's Hospital, board certified in adult and pediatric medicine. He testified he has significant experience with CRPS. He told you it was regional, and he used the Budapest criteria. And back then, he started what we believe is the evidence-based medicine, and it's simply this. CRPS or conversion disorder, the treatment is physical therapy, occupational therapy, and cognitive behavioral therapy. And at Lurie's, ketamine, intrathecal clonidine pumps are not what they use. Then there was one of those things where we call sort of a dramatic moment at trial where my partner, Mr. Hughes, put up the picture of one of the scratches at All Children's that the plaintiff claims is a CRPS lesion, and asked him, what do you think? He said it was a scratch. That was his opinion, which is going to go, we're going to come back to that when we get to the All Children's admission. She was seen by a pediatric psychologist, Dr. Lowry, who also noted an exam inconsistent with the history. And again, their belief at this world-class hospital was conversion disorder. But importantly, her recommendation, as she told you under oath, was for non-pharmacologic intervention for the pain. You also heard testimony from Dr. Elizabeth Byrne. She was a pediatric hospitalist that at that time was also assessing complete and normal strength in upper and lower extremities, and believed this was triggered by conversion disorder and wrote it in her note at Defense Exhibit 3032-127. And she specifically wrote on that date back on July 24th, 2015, that the exam was not consistent with the history, which raised the concern for a psychiatric component. And this is the important part. She will likely benefit from a therapeutic program that combines physical and psychological therapy to address both weakness and pain access, and with the appropriate therapy, she's going to return to baseline. Remember that, because this is the exact recommendation that's made at All Children's, as we're going to see, and not just All Children's. The family returns back to the Tampa Bay area and checks into Tampa General Hospital under the care of Dr. Kornberg. Dr. Kornberg, on his very first visit, writes in his note, and again, this is at Defense Exhibit 3047-21, that there were some inconsistencies in his exam. That's okay, but his impression is now exactly the same as what Dr. Kilgore wrote at All Children's, which is exactly the same as what Dr. Byrne wrote at Lurie's, that this is psychological factors affecting physical condition. His first impression of the case. Then we get to Bonnie Rice. It's an interesting comment about Bonnie Rice in opening argument. You may remember it, you may not. It's been a while. But the plaintiff said, this is the Kathy Beattie of Tampa General. Like there's a county-wide or Florida state-wide conspiracy among providers who have never met each other. But they said it because they don't like what she had to testify to. Because what Bonnie Rice testified to was that there was a psychological component, and then talked about some of the family dynamics that Dr. Wyndham talked about, and I don't mean to bring this up to cause any more, embarrassment, but this is an important issue because what Bonnie Rice said was that Maya was telling her about how her mom was working and how she was trying to get her attention. She talked about the feet going inward and outward volitionally. And she talked about how mom was respectfully asked to leave to see if the condition would improve, and it did. And that there were multiple stories about falls that Maya had told them at Tampa General, and they put her on video monitoring. Dr. Kornberg does his own independent assessment, reassessment a week later, and notes volitional movement in all extremities, but the performance is variable, and documents that Maya is now asking for more oxycodone when mom is present with her. Saying the same thing as nurse practitioner Rice. And then we get to what I believe you found was dramatic testimony from Dr. Jennifer McCain, who came here and testified before you and repeated a lot of the same statements that nurse practitioner Rice saw. And the neuropsychologist, the director of pediatric neuropsychology at Tampa General, testified to what she wrote in real time about Maya being upset with her mom always working, about Maya having difficulty with movement in that discussion. And respectfully and honestly, Mr. Kowalski, according to her record, had told her he saw a lot of the same. A lot of the behaviors were filled with exaggerations. And then there was a comment that didn't probably appear as important at the time, but becomes important later when we get to 2016, about Maya not being motivated to return to school while she's recovering. And what was Dr. McCain's diagnosis? Psychological factors affecting physical condition. This is what we mean when we talk about standard of care, right? This is what we mean. We're going to look at the jury instruction later. What do similarly situated healthcare providers do under similar situations? You can see the pattern here. And back in 2015, Dr. McCain was recommending follow-up for mental health professional services, including psychological and psychiatric. And so when you're thinking about damages in this case, and when the Kowalskis are asking for, we'll talk about it, but money for future psychological care, this recommendation is being made far before Maya comes to All Children's. And then there was another dramatic moment at trial, and I think you remember it because it was sort of one of those silence is deafening moments where they showed Dr. McCain the video of Maya trying in therapy and the giddy up horsey. We've seen it a few times. And Mr. Anderson flat out asked her on the witness stand, "You still think this is conversion disorder?" She said she still believes it. We heard from a wonderful therapist, Marissa Higgins, and she loved Maya. Absolutely. She came here to advocate for Maya. She should. She's her therapist. But she had to also acknowledge the uncomfortable fact, it's that Defense Exhibit 3047, 3055, page 7, that there was a difference in behavior when Maya was with her mom versus when Maya was on her own. And she noted attitude of family, attitude of self. And if you're wondering, why am I going through all this? Because Mr. Anderson just sat up here and told you, why did All Children suddenly have alarms raised? Where did this come from? The pattern is building. It wasn't just then. On the discharge summary from Dr. Kornberg, who you heard from, who, by the way, we had to read him. No one was wearing wigs to have a moment of fun, but we had to read his testimony. He flatly denied saying he was going to break Maya's legs, and his nurse practitioner said that's not anything this kind doctor would do. But now, after being seen by pediatric intensivists, neuropsychology, psychiatry, neurology, dietitians, undergoing an EMG study where they're putting needles, arms, back, everywhere, which was fully tolerated without any sense of pain, this was the discharge diagnosis at Tampa General. Suspected conversion disorder versus factitious disorder. And all they recommended at Tampa General was this. If you go through physical therapy, occupational therapy, it's going to be painful, right? You're going to have to work through this. Non-narcotic medication, maybe some medication for pain control, you're going to improve and recover. That's what Dr. McCain testified to when she was on the stand. My belief is this child is going to recover and be back in school in August. And Dr. Kornberg reinforced it when he said to the Kowalskis, stop taking these medications, including the oxycodone. I'm going to try to orient you to some of these events by what I call little charts, because it's a lot of information to take, and this is just my sort of demonstrative to show you that in what's less than 2 months, from July 4th, we go from wheelchair to hospital, 3 diagnoses at All Children's, Lurie Children's, and Tampa General, 3 world-class institutions, multiple specialists seen by pediatric neurologists. They've all coalesced around the same diagnosis. Suspected conversion disorder. That doesn't mean your pain isn't real. It just means what you need is physical therapy, occupational therapy, and cognitive behavioral therapy. And you should return to normal. And by the way, not just them, right? Not just them. Defense exhibit, actually this is joint exhibit, the J is joint. Joint exhibit 1066, number 3. Dr. Wassenaar, their trusted pediatrician, what did he say? When he saw Maya after being released from Tampa General, he wrote in his record too, there's significant behavioral overlays complicating the assessment, and noted his concern that despite seeing the note from Dr. Kornberg to stop taking the oxycodone, that Maya is still using 2 milliliters of liquid oxycodone several times a day. And what did he write in his impression before anyone thought we would be here in court? Joint exhibit 1066, his impression. Behavioral disturbance with possible conversion disorder. The same diagnosis being made at 3 other hospitals, their pediatrician. And somehow all these people missed what they believe is the diagnosis of CRPS. You know where this first appears? I think you caught this, because everyone here is taking great notes and taking great attention. Mr. Hunter noted this. This is where this appears. The first time you see RSD in the record is from a note from Dr. Kriesman. He's a pulmonologist at All Children's. And he notes in his record that reflex sympathetic disorder is the most current diagnosis. She got this from a Facebook group. Talking, I think the testimony was she had a friend, Beata had a friend who had RSD, and she came up with this diagnosis despite 3 world-class hospitals and their own pediatricians steering them towards what the proper therapy and diagnosis was. And even again, Dr. Kriesman is encouraging the family to continue psychotherapy and plant some seeds to continue therapy. Then we get to Dr. Kirkpatrick. No board certifications, no hospital privileges, meaning he's not submitting his credentials to a hospital committee to say, can I practice there? We've heard from Dr. Bifolco what he charges. Actually, I think it's $12,000 now for cash for 4 days of ketamine. And he testified that Maya had a poor response to his treatment, so he had to send her to Mexico. But look what he wrote in his note. Joint exhibit 1056. He wrote, it's also been suggested there's a psychogenic component to her pain. Was it reasonable for him, knowing that, to start pushing ketamine? And look what he also wrote. He recommended evaluation by a pediatric internist. And then he discussed the risks of ketamine, which have been tried to be downplayed in this courtroom. But fortunately for all of us, Beata Kowalski took excellent notes, didn't she? You've seen a lot of her emails. She took excellent notes. Let's hear from her. Here's her Facebook post. 10/12/2015. This is after Dr. Kirkpatrick. Tuesday was a lot harder than I expected it to be. She had hallucinations with monsters, which made her feel very scared and terrified. Mumbled, double vision. It was just Maya, ketamine, and me taking this curvy, bumpy road to fight RSD. This is really important what's written next. This is really important what's written next. STM, short-term memory. Short-term memory challenges were hard to handle. Couldn't remember my name, where she was, state she lives in. Here's what's also important. Ketamine's no big deal, right? At the end of the infusion, her saturations went down into the 70s, and she couldn't breathe well on her own. This is being given in an office, not in an ICU setting. She got very close to becoming intubated. This is what I mean when the defense says unnecessary medications being given at dangerous levels. And so here's the timeline for 2 more months. She's back at All Children's getting the MRI. We see the record from Dr. Kreisman. We see the diagnosis from Dr. Kirkpatrick on the first visit. And then 4 infusions, the refill of oxycodone from Dr. Wassner, and she's already in All Children's Hospital for abdominal pain. And Dr. Kirkpatrick had to write her not 1, but 2 refills for a hydromorphone pump. And by the way, this is before she could even get to Mexico. Was the ketamine working? Did they need a hydromorphone pump? This is at Defense Exhibit 3402A. You're going to see this exhibit contains not just the hydromorphone, but all the oral ketamine that was being drank in the meantime. They go to see Dr. Cantu. Cash pay. If you look for his records, you're going to find few. I can't direct you to them. Apparently there's some labs in there, but I can find very little. To his credit, one of you asked an excellent question. An excellent question. Among all the great questions, I thought this was one of the better ones. Dr. Cantu, is this coma controversial? Because it's obviously they don't do this in the United States. And he said, yes, it is controversial. We do this as a last resort when everything else fails. Right? That's what he said. This is being done to Maya less than, 6 weeks after Kirkpatrick gave her the diagnosis? And again, Beata Kowalski, to everyone's benefit, wrote exactly what's going on at this point. I'm the youngest child in history who's developed severe generalized RSD, and I'm the youngest child who's going to be placed in a high-dose coma. Acknowledging this procedure is high risk due to all of these complications, and they're at risk of total body failure and death. Coma day 2. Gagging in her throat with, thank God my mommy was right there, she helped me to suction my mouth to prevent death. There's the recollection of ketamine giving magical powers. And when you look at actually what happened, what they were worried about the front end, remember the sepsis and the death? It's right here. Last night was rough for me. My temperature went up again. I became tachycardic, heart racing, and restless. The sputum gram stain came back positive for gram-cocci. Now they have to give the antibiotics. And then the statement at the bottom, she's got a high tolerance for drugs. The amount they were giving her, if she was a horse, she would be comatose or dead. It continued throughout the coma. I don't mean to belabor this. This was not a spa day in Monterey. This was a very dangerous procedure that almost ended her life. All of these are back in evidence at Defense Exhibit 3148. Upon return to the United States, they saw allergist and immunologist Dr. Alvin Mendez. He came and testified to you. Remember his testimony. He talked about that, again, just like Dr. Wyndham, he didn't see the asthma, normal lung function. He also expressed his concern about all the steroids she's getting, unnecessary medications at dangerous levels, and that, as he wrote in his note, he was concerned about a psychological component to this. He said Munchausen's by proxy. So when the plaintiff said, after Dr. Kirkpatrick got involved, nobody ever suspected anything other than CRPS, not true. Not true. Dr. Mendez did, and he put this on a letter to Dr. Wassner. It's at Defense Exhibit 3031, number 10. Let's look at our timeline. Now just November and December. Remember, this is only 5 months after the 4th of July, riding the bike normally on July 3rd. Not just the coma in Mexico, but we're back to Mexico again for booster and booster and booster. And they want to tell you the ketamine's working. Well, let's see if it worked. Beata Kowalski to Beata Kowalski. Relapse January 13th. Blurred vision, massive headache. The pain in my head is so intense I could hardly say anything. Worse each day. Relapse. And by the way, look at the last line. I was taking the ketamine ATC around the clock. every 3.5 hours. So when you look at the chart of infusions, does it include the ketamine she's drinking, the anesthetic that she's drinking? This is in addition to that. We get to Dr. Hana, and again, no hospital privileges. Advertises his services at ivketamine.com and nopainhana.com. No referral. Told you he didn't know whether any psychological counseling is going on. He's the one who prescribed the oral ketamine. And fortunately for all of us, Dr. Hana puts in his records these, you've seen these. He does it almost for every visit. January 25th, 2016, quality of life is 2. After the coma, after all those boosters, after Kirkpatrick, and then we get to Dr. Barr. Him and Mr. Hunter got a little testy, but he ultimately told you he wasn't the one who made the diagnosis of CRPS. But then we got to, again, wonderful jury questions from one or more of you. And if you remember why, he came on right after Dr. Chopra, right? I think it was the next day. Somebody here asked the brilliant questions because Dr. Chopra tried to downplay ketamine. Dr. Barr, thank you for your service. Let me ask you this question. Do you think ketamine has these symptoms? Withdrawal? Yes. Nausea, vomiting, heart racing? Yes. Is there a risk of addiction? He said yes, depending on the length of treatment. And then the ultimate question, do you use it? No. I recommend the evidence-based approach of non-narcotic pain control, physical therapy, and occupational therapy. And then he wrote in his note, which is at Joint Exhibit 1039, that her pain was throughout her body. It's like fire. Is this ketamine working? Well, let's go back to Dr. Hana. Quality of life 3, March 25th. Month later, quality of life 3, April 25th. Look at the timeline. Over 30 infusions just from January through April. Going back to All Children's Hospital in January for abdominal pain. This doesn't even include all the oral ketamine, which we can't track. Then we get to Dr. Spiegel. Dr. Spiegel is giving hyperbaric oxygen therapy. No one here is criticizing it. If the Kowalskis wanted to pursue it, ultimately it's, I think as you heard, it's a relatively benign treatment, whether it helps or hurts. But his consultation note is what's interesting here. Because he was unable to examine Maya when Mom was present, but when Mr. Kowalski was there, he could. Is the ketamine working when a neurologist writes in his record on May 13th, 2016, that she has whole body pain and was a vegetable due to severe pain? Is it working? What about his exam of the extremities? No change in temperature, no change in color, no swelling. That's what edema is. And then you remember you saw this medication list? This is an evidence. 2 full pages of it. Let's go back to Dr. Hana and see if the ketamine's working. May 13th, 2016. Still a 3. June 24th, 2016. Still a 3. Let's hear from Beata Kowalski again. Week of 7/10/16. In addition to the 5 treatments of hyperbaric oxygen and 3 days of ketamine, 3,000 milligrams, I've been very forgetful from the ketamine. Short-term memory is definitely a problem. Sometimes I can't tell if it's AM or PM. Did I even eat breakfast or not? Did I have my ketamine yet? Did I go into the chamber? Everything is just a blur to me. Back to Dr. Wassner, and you heard the testimony that Maya was asked to go back to school, and the Kowalskis challenged that. What did he verify as a signed statement to the school on the hospital homebound form of August 24th, 2016? Is Maya under medical care for an injury that is acute, catastrophic, or chronic? Yes. Remember that statement when they're going to come back and ask my client to pay them $30 million for future CRPS care, $10 million or whatever the number was. This is 2 months before she comes in, and she's too sick to go to school. In fact, Dr. Wassner said she cannot even attend school with an accommodation, and she has to be hospital homebound. Is the ketamine working? Back to Dr. Hana. Here's the letter he wrote to the school district. Maya K suffers from horrific disease, RSD, CRPS. Look at the pain scores. Look at the pain scores. 10 out of 10, 10 out of 10, 9 out of 10, migraine 10 out of 10, severe weakness, nausea, vomiting, and then this statement. She's unable to eat or drink for 3.5 days. This is serious for a child this age. Here's the timeline. May through September. 19 more infusions plus who knows how much oral ketamine. And Dr. Wassner is saying she can't go back to school. It all culminates in this. On October 5th, 2016, Dr. Hanna at Joint Exhibit, I don't have the Joint Exhibit, I apologize, it's in his records. He writes a script for the malnourishment. Nutritional consult needed due to patient being malnourished, low body weight, iron deficiency, anemia, and chronic nausea. And we learned on the last day of rebuttal testimony from Mr. Kowalski when he took the stand. I wasn't aware of this. Mrs. Kowalski was at this appointment. She wasn't taken to the doctor that day. Mr. Kowalski went back to Dr. Hanna's office. And here we are. And here we are. 55 infusions, a ketamine coma in Mexico, boosters in Mexico, oral ketamine occasionally around the clock, days of not eating, days of not drinking, short-term memory problems, and her quality of life is a 0. And if you want to know why All Children's intervened, it's because of this. Look at what it's, by the way, this isn't just ketamine. This is 100 milligrams of Versed needed to control agitation on October 6th. 2 vials of ketamine, 14 vials of Versed, 8 vials of Zofran for nausea and vomiting. You can find this record at Joint Exhibit 1040. You know what's even more shocking is the weight. You can check his records. She didn't gain a pound from when he started seeing her in January until he finished seeing her in October. Look at what, this is the old meme, how it started, how's it going? January 14th, 2016, his infusion started over 4 hours with 1 vial of ketamine, 8 vials of Versed, 4 milligrams of Zofran, and by the time he's done, 2 vials of ketamine, 14 vials of Versed, doubled the Zofran to keep the nausea and vomiting down, magnesium sulfate, and now we're up to 100 milligrams of Benadryl to control for the allergic reaction. This is what this looks like. This is what this looks like. Look where Dr. Patrick started. These are high doses, by the way. The green line at the bottom is what Dr. Crane testified to, the low dose that they use for refractory CRPS occasionally. These are the doses. In fact, I ran out of room on the right. 24.1 milligrams per kilogram per hour. I think the testimony is 30 to 200 times the dose given in an office. And to Dr. Hanna's credit, he did say, I sent her to All Children's because I failed to help her. This is not ketamine working. He failed to help her. He could not control her pain with maximum doses, and he was not comfortable going higher. You have heard a lot about the hurricane, right? Like why are the Kowalskis so insistent on saying when we went up for a hurricane, we know they were staying at the Ronald McDonald House? Because they know if this is true, what Dr. Hanna said, it's an admission that the ketamine failed. It's an admission that the ketamine failed. And now we get to my client's institution, the hospital that I have the privilege to represent. No signs of withdrawal. What was the very first thing Dr. Bayar Posey said in the emergency department? Her differential diagnosis she testified to by video. Differential diagnosis, number 1, withdrawal, including the abdominal issues, and having to cancel exams because they wouldn't give 1,500 milligrams of ketamine in the ER. Dr. Tepa Sanchez spoke to you. Board-certified pediatric critical care medicine. She was kind, but she talked to you about what she saw. Mom demanding a ketamine coma with intubation. This allegation that we're trying to falsely imprison her, we were trying to transfer her from moment 1 because we are not an acute care, a chronic care facility that at that time was able to treat whether it was psychosomatic disorder or whether this was complex regional pain syndrome. That required long-term treatment. She testified to you under oath the family never asked to leave. How about Dr. Dolan? She testified with you too. Oh, and by the way, I think it's important to note that the diagnosis that appears in our record that you see at the bottom, chronic diagnosis, complex regional pain syndrome diagnosed by outpatient physicians. It wasn't our diagnosis. We respected it. My clients respected it, tried to treat it. This was not a diagnosis we came up with. This was a diagnosis that came from an outside provider. Dr. Dolan noted the same thing again, first day of admission. Mom requesting a ketamine coma. Dr. Dolan told you that she was shocked by this. Dr. Dolan also told you she reached out to Dr. Hanna. They weren't ignoring the outside consultants. They were getting her input. So why did All Children's intervene? Why did All Children's tell the Kowalskis, we would like you to stay? They did not tell them you cannot leave. They told you we would like you to stay. It's safe to stay here because of this. Because of Nurse Thatcher, her notes. Mom asking to prime the lines with propofol? Giving rewards of Valium for tolerating a CT scan? And the hospital's supposed to look the other way on this? That's the coward's way out. What about these notes from the ICU? What about the one given by Nurse Klink? I'm tired of all these lies, my life is a lie. They're supposed to ignore that? Remember that statement because it repeats itself in Dr. Lewis's report. How about this statement? Maya hasn't eaten 5 days because she's not allowed? And then this is the ultimate one. Mom says if we can't get her pain controlled, we may as well consult hospice so she can finally get enough medication and just let her die. The coward's way out is to let them leave. People who care about children do not let that child walk out the door without talking to the family. This is alarming. And you know what? They did. They did. And what was even more alarming about this is you hear these statements about a hospice consult, and at the same time, some of the nurses are saying she's totally fine and resting comfortably when mom's not in the room. You remember this. And if you think I'm making it up, let's listen to Mr. Kowalski.
When nobody else was in the room but Maya and the staff, she acted completely normal. When Mom would walk in the room, she was instantly
I heard that many times.
There's no other explanation
I-
for that.
Yeah, I noticed it too with myself being home, and then Mom comes home from work,
And all of a sudden she's back.
there will be changes, yes.
So you're at home, your guys are doing well, and playing.
No complaints about pain.
No complaints about
But
that.
then when Mom gets home,
She's in
maybe-
pain.
Let's talk about the period where they're alleging my clients imprisoned them from October 7th through 13th. This is a relatively straightforward one because my clients took meticulous notes during this time period. Dr. Dolan, discussing the weaning plan, recommending transfer to other facilities. For a hospital that wants to imprison someone, this is awfully bizarre behavior. This is that Joint Exhibit 1001-633. Look at the bottom. We had a long conversation with the parents. Look at what they're recommending in the second paragraph. Recommend CBT, psych involvement for treatment, as this is part of the standard of care for CRPS. Respecting the diagnosis that this could be CRPS. What she needs is long-term cognitive behavioral therapy and physical therapy. And they're trying to find the services for it. And not just Dr. Dolan, but Dr. Elliott. Long discussion with the parents twice. Parents in agreement with plan of care. That's October 11th. How about Dr. Smith? She came and testified to you. Discussing the weaning schedule with the mom, it was all agreed to. How about Dr. Smith the next day? Again, keeping the parents completely involved in the discussion who agree with the plan of care. Now, if only we had an email to put all this to rest, right? Wouldn't it be nice to hear from Mrs. Kowalski? What'd you think? That would help settle this, wouldn't it? Beata Kowalski to Jack Kowalski, talking about being accused of trying to take Maya AMA against medical advice home. That's a lie. That's plaintiff's exhibit 2408-1739. It's in her own writing, written to Jack Kowalski, and there's no reply in the state saying, actually, I do want to take her out. And you know why? Let's listen to Jack Kowalski again.
I mean, when we were in the meeting with the doctors one day, and Beata wanted to take Maya out, sign her out, and I said, hold on, time out. And this wasn't in the, wasn't written down, which I was kind of mad about, but I asked the doctors, I said, what's the time frame you're talking about? And they explained. I said, that's doable. And was my wife happy with what I said? No, absolutely not.
Okay.
So you have to, there's times I'm going to go the other way.
Okay. And thank you for sharing that.
I don't know why they didn't write that down.
I don't know why they didn't write that down in my agreement to stay. Let's talk about the EEG room. This is their second allegation of false imprisonment. You heard from Dr. Paula Dees, who ordered this study, and she told you she ordered it for clinical purposes, and we know that because she testified to the inconsistencies noted in the record. Those are real. The inconsistencies are not something that originated with Dr. Dees in her mind. We went back in time and showed you all of the records from Tampa General Lurie's. We don't need to go backwards. But she had a resident order it in the seizure monitoring unit, and she believed she had consent. And by the way, she noted in her record that there were no acute events overnight regarding room 709. Dr. Dees told you she believed she already had consent from a signed consent from Mr. Kowalski, who has testified to you he never revoked it. And as part of the consent, which is at Defense Exhibit 3002-001, there was an understanding that this could include videotapes, photographs, and closed-circuit television monitoring of patient care. Let's look at the room. Defense Exhibit 3304-001. This is the dungeon. This is a room like every other room. There's no difference in the room other than in the top left corner, unlike the other rooms, this one's got a camera. It's equipped so they can watch children having seizures. It's also equipped to do monitoring if the doctors have concerns about seeing inconsistent efforts. We have video of what went on. It's all been provided. Dr. Dees wanted to know if this was possible. Could Maya tolerate the blood pressure cuff? The room where she has her teddy bears and blankets? Is this the dungeon they're talking about? Where they're brushing her hair? In her dress? And by the way, there's been a wild allegation that Maya was left in her feces and urine. They've had that video for 5 years. If that was true, you would have seen it. If that was true, you would have been shown evidence of it. It didn't happen. If you want to know whether this is standard of care, look back at Tampa General, Defense Exhibit 3047-0674. They did the same video surveillance monitoring there too. The Kowalskis are not suing for invasion of privacy. They're suing you for false imprisonment and wanting to know, the jury instruction on this, and go to your package, is whether all children's had authority and consent. Where's the restraint? Where is the restraint on this? Where would punitive damages even be considered involving a false imprisonment of intentional misconduct when they're putting Maya in the same room as any other room to check her true abilities, combing her hair, bringing her in and out of the room for different therapies? On the balance of probabilities, the only thing you've ever heard is Mr. Kowalski tell you that some unidentified person threatened him with arrest. That's it. And on the other side of the scale, you have the signed consent form, 5, 6, 7, 8 notes agreeing with the plan of care, but you don't have to listen to our records. You have Beata's email and evidence. You have Mr. Kowalski's voice and evidence. And this EEG room is identical to others, and that's important because when you look at the judge's instruction on what false imprisonment is, the person has to know they're being restrained. The person has to know they're being restrained. And if Maya doesn't see a difference in the room like any other room they can't prevail on this count. Let's talk a little bit about Dr. Sally Smith. This part's undisputed. She has no orders in the chart. And by the way, this is actually quite important, so let's make sure everyone understands. There's obviously, and you've seen so many sidebar conferences about the dependency court's not part of this action, right? You've been told over and over again, All Children's Hospital is not responsible for the separation of Maya from her family. We are not being sued for anything that Sally Smith did in her role on the child protective side. It's only if you think that she did something on the medical care and treatment in the hospital you could hold us liable for. So if you're in the deliberation room wondering if you're checking the box for Dr. Sally Smith, and I would implore you not to, and I'll show you why, it would have nothing to do with went on in dependency. That's not part of this. She never directed treatment. She made suggestions for what she needed, and you heard from Dr. Alexander that All Children's absolutely has to cooperate with the CPT investigator, that at all times Dr. Sally Smith was acting in her role as a CPT investigator. The idea that there's something improper about our hospital, our employees who care, calling Dr. Smith on a, what do you think? Given what we saw in the ICU, including the statements of talking about terminal hospice, that they're going to pick up the phone and say, hey, you've been at this for a while, what do you think? Would they prefer the standard of care be like just call the abuse hotline every time? This is exactly what you want people to do in this situation. And again, on the question of a parent agency, we got a document. So this is going to be helpful. Again, Plaintiff's Exhibit 2408. They've told you we had no idea who Dr. Smith worked for. Beata Kowalski to Beata Kowalski and Jack Kowalski. October 11th, I had another supersized visit from MD Dr. Smith, who was sent by Child Protective Services to investigate. The question of a parent agency arises in terms of what the hospital held out, what the Kowalskis understood. It's right there. This is an easy one for you to check the box on. Let me transition back to the medical care. If there's a document that I believe you should spend time on, it's the neuropsych report of Dr. Lewis, because it answers a lot of questions. Not the doctor from All Children's Hospital. Okay? He met with Maya and submitted a psychological report on October 18th, 2016. We can walk through this. Maya denies a lot of statements in here, although in fairness to Maya, she said she didn't read it. The plaintiffs have tried to contradict this, and they have to, right? They have to, because what's written in here tells a story. I'll leave it at that. Joint Exhibit 1046-0007. The first thing that I thought was important to recap here is, well, Maya was drugged up, so the statements she made couldn't possibly be true. Remember that? Except in the very first part, they talk about the 3-hour session going on, and it was noteworthy that Maya wasn't in pain because she hadn't taken any pain medication that morning. Maya talks about some of the abuse that, we're not here to over-dramatize, but it's there. And then she talks about childhood memories and her fear of being told about the ketamine coma and the 50% chance of it killing her. And when you're asking the question, has Maya suffered trauma in her life? The answer is yes. Did All Children's cause this? The answer is no. Remember that statement, my life is a lie, and they went after Nurse, I believe it was Nurse Klink on the witness stand saying, where'd you get this from? You're making this up out of whole cloth. Look what Maya said to Dr. Lewis on October 18th, 2016. I really don't want to have the RSD, and I really don't want to go back on all those pills or have the ketamine anymore, but I am afraid to tell my mom how I really feel because I don't want her to be more sad or upset than she really is. She talks about in the last paragraph about getting back on the medicines that could have killed her. What did Dr. Lewis say about the effects of ketamine on her developing brain? He discussed psychomotor slowing, a known consequence of prolonged use of benzodiazepines, Valium, and dissociative anesthetics such as ketamine. He didn't say this in preparation for a lawsuit. He wrote this in real time out of grave concern for Maya. And then he wrote that Maya has numerous findings in her clinical diagnostic interview of trauma, and that this and the depressed mood need to be a focus of individual trauma therapy. The recommendation for trauma therapy occurred before All Children's ever got involved. He met Dr. Jennifer Katzenstein, a neuropsychologist with All Children's Hospital. Her diagnosis is identical to Dr. McCain's at Tampa General, identical to Dr. Lowry's at Lurie Children's. Psychological factors affecting medical condition. And by the way, she had a very pleasant interaction with the Kowalskis, and I would suggest to you that, Maya's behavior at All Children's was wonderful after they got out of the ICU. That was the two differences in the witnesses that you saw of people talking about the chaotic scene in the ICU is real, right? It's documented. But by the time Dr. Katzenstein gets involved, and the weaning had been done and the withdrawal symptoms had been done, and then the Kowalskis say, well, how dare you, All Children's? You didn't do all the cognitive behavioral therapy that is necessary. This is why they were trying to transfer. And indeed, Dr. Kilgore wrote that the treatment for her physical symptoms and inability to walk from conversion disorder is intensive cognitive behavioral therapy, and we do not have the staffing here to accomplish it. This is why they were trying to transfer Maya to an institution where she could get the rehabilitation. And nevertheless, despite, as written here, Dr. Katzenstein having a full patient load, she walked over to All Children's Hospital, I believe it was somewhere between 15 and 20 times, gave 5 hours of cognitive behavioral therapy, and would have given more, except she rightfully respected some of the times. Mr. Kowalski was visiting with her daughter and said, that time's more important to you. But this is why they're trying to transfer. And this is on Defendants 3115. And when you listen to this, you tell me if you think that Ms. Beatty is speaking with anything other than kindness.
Can I help you?
Hi, Maya's mom. This is Kathy Beatty with All Children's Hospital. I'm the social worker. I'm here for Maya.
Okay, how can I help you, Kathy?
We have the, excuse me, I'm sorry. We have the acceptance from the morgue, and we are getting ready to transfer her to the morgue, but we need your consent to do so.
We have a meeting today in regards to Maya's future plans. So we'll have a meeting today in regards to that at, I believe, at 3 or 3:30. And we're meeting with our attorneys today regarding that issue.
Okay.
So
are you giving us consent or are you declining consent?
I'm not doing either till I speak with the attorney and the coalition. We have 2 meetings today.
The wild allegation that Kathy was trying to be her mother at the same time she's trying to transfer her to a hospital in Orlando makes no sense when you see that Miss Beatty is doing everything she can to get Maya to the right level of care. And if you want to know why they really weren't anxious to get Maya out of the hospital,
My bigger question is, why would a parent go to these extremes?
Because I'm told this is the last resort.
But you're saying it's not. And this is not, I mean, all it would have taken was a question from you somewhere along the line that are we doing the right thing? Maybe we should go back and talk to another doctor, do something more conventional, not something that's likely to kill her.
I'm receptive of keeping her here. That's what I told you. And if they think something else, I'm supportive of keeping her here and looking.
that was on November 18th, 2016. And by the way, this is important. It came up earlier, and the plaintiffs haven't argued it, but they are not seeking damages in this case for allegations of Munchausen by proxy. You can put that out of your mind. Not from this hospital. Despite Maya staying at All Children's, and despite not having the cognitive behavioral therapy in the amount that was necessary, Maya was still seen dozens of times by Billy Cecil, who you met. He told you about his significant experience with CRPS, and he told you about the improvements that he saw. He told you by the end of his sessions that Maya was able to sit in a wheelchair with no back support, no arm support. And one of the jurors asked him, is this still evidence-based medicine? You saw her in 2016. Is this still what they do for CRPS? And he told you yes. The physical therapy is the evidence-based practice. I want to transition to something that's very important because it was a big deal until the defense got the case. You remember in the trial there was a lot of objections. You know, they did this. Objection, watch your pronouns, right? Watch your pronouns. The Kowalski's anger, rightfully or wrongly, is that the people in yellow, the people that took the communion, the people that blocked visits rightly or wrongly, they owned it. Now, I've given you a timeline. I don't want you to rely on this, okay? It's not going back in evidence. The judge has given you an order. The orders on visitation. They're very important to watch. But here's what you need to realize. When you're being told or when you're assessing evidence of whether a visitation was denied, whether something was taken, I need you to ask this question to Liberation. When and by whom? When and by whom? Was it during a period that no one was allowed in? Was something taken by somebody that was sent by DCF, not by All Children's? Because you heard from Charlotte Laporte that all communications had to be supervised and that she stopped some correspondence from going to the hospital. She told you Kathy wasn't part of the calls, and she confirmed that the voice on the recording was hers.
I would love to see a son. I would love to see a son. We just have to wait for the judge to make the decision, okay? As soon as he makes the decision, then I'll be able to see you. Okay? Yeah.
We're not allowed about the case, okay? Maya, honey, we're going to talk about what you've been doing, if you need any Shopkins or things like that, if you had nice visits with your daddy, but we can't discuss the case, okay, honey?
That's not Kathy's voice. They know this isn't Kathy's voice. They needed to have you believe this was Kathy's voice because they've got to find something outrageous. Not that an interruption of a call would get to that level. She's talking about Shopkins. She's from the upper Midwest. But the thing about this is, we don't have to guess, because again, I got an email for you. Look, and just so we're on the same page here. November 15th, 2016, look at the email the next day. Charlotte Laporte to Beata Kowalski. Also, yesterday when you were on the phone, I had to redirect you due to the case being brought up and mentioning of the judge and his decisions. This is thank you, Your Honor. This is Trial Exhibit 3217 at 573. The interruption of the phone call wasn't Kathy. I don't know. I'll leave it at that. But the need for redirection, whether it was by Charlotte Laporte or whether it was at a time, and again, you have to ask who and when All Children's was allowed to supervise calls, was because of this.
Because I know Mom talked to her once, and that was supervised. And I guess she got shut down many times because she was smaller off.
She could.
Why can't Mom?
You heard from Tori Nias. She was a Save Children's Coalition person. She took the stand. She took ownership of this situation, didn't she? She told you that she was advised by Charlotte Laporte and Lizzie Massica about what items could come in and what could stay. She told you she was the one who removed the communion, the iPad, the food from the fridge. She allowed some items. And again, whether you think that was overzealous, whether you think that was justified, is not an issue in this trial against All Children's Hospital. No one's alleging she's our agent. You heard from Lindsay Massica. She told you she was the one responsible for DCF background checks and visitors and what she prohibited, razors and communion, about what she allowed. And again, whether you think that was right or wrong, she's not All Children's. So that's why you have to ask who and when did these incidents go on. Now, there were religious visits, and take a look at the top note. Who helped arrange them? Kathy Beatty, 11-8. Social worker worked with pastoral care for Maya to get communion. We know from Father Costello, he came and had a visit with Maya. If he was denied a visit, you have to ask by whom and when. We know from the notes that both Father Herbert and Father Coover also visited, provided Holy Communion, emotional support. So why is Kathy Beatty being vilified in this situation? Well, because of this. For better or for worse, social work is assigned as the liaison between DCF and the hospital. The same way social work is assigned as liaison when you're getting discharged. If anyone here has ever been discharged or worked with one for your mom or dad to get to long-term care, they're the ones who help coordinate it. She was the bearer of bad news on October 13th and became the face to the Kowalskis of the communication. She's been accused of a lot of things that are just false. I'll just tell you they're false. Remember the dress? There was a request to bring dresses to the office, and she told Mr. Kowalski, this is in evidence 3217-0784. Thanks for the update. She'll be happy with her dresses. And then you heard from, there was a big deal about she never got her dresses. And then you heard from social worker Padron, who didn't just testify to it, she wrote it in the record. This worker dropped off Maya's dresses plural. Maya appeared in good spirits and showed a lot of excitement for the dresses. We have photos of the dresses. More photos of the dresses. These are all in evidence. We have photos of the birthday cards. The reason why the original card didn't get through was because they had to be scanned to Charlotte Laporte, who then sent them to Kathy to print and give to Maya. So if the Kowalskis still have the card with the lipstick on it, that's why. This is at Defense Exhibit 3217-718. The scanned card was printed and delivered according to the sworn testimony of Miss Beatty. But unfortunately for Miss Beatty, she became the face of the bad news. She testified, I was the one who had to tell Maya that she couldn't go home for Christmas. Again, they're not blaming us for her not going home for Christmas. That's a totally separate issue. But she prayed with Maya. She admitted to you that she had Maya on her lap. Not running from that. But I question where we are. That we've gotten to the point where a social worker comforting a child that she's not going to home for Christmas and puts a child on her lap is now a battery? And look at the jury instructions at page 20, because the judge is going to instruct you on a battery. It's not what I want the instruction to be or the Kowalskis. It's what would a reasonable person consider a battery. And I don't want to misquote the instruction. Read it. It's at page 20. The judge has given you excellent instructions. Would a reasonable person consider putting a child on their lap in that moment to be a battery? Is that where we are? Oh, by the way, let's talk about next what I know has made some of you uncomfortable. So let's talk about this head on, the photos, okay? There was no personal cameras used. There was a reason why the photographs were taken, right? So this is January 6, 2017, Dr. Kristen Danielson at the bottom. There was the concern about quote, in air quotes, skin lesions on the forehead, which appeared to be self-inflicted. Dr. Major wrote the same concern a week later. So the hospital set about documenting photographs of these for the reasons that were written by Dr. Danielson and Dr. Major. And that leads us to the photos that they're upset about and that I know some of you are upset about. This. I'm not going to gaslight you on this and tell you that Maya looks happy. She looks miserable. She does. She's not being held down, though. They're documenting her skin condition twice before she leaves for court and when she comes back from court. And Kathy Beatty told you that's part of her procedure in this situation. Okay? We see the nurse's hands holding her hands, not holding her down. This is part of what they believe is their protocol. And you're wrestling with this. Again, if they just photographed her face, maybe it's not as important to you. They lifted her shirt. There's no... Kathy Beatty and Nurse Alcida, who came and testified to you, absolutely denied that she was stripped naked in front of everyone and violated her dignity and privacy. But they took the photos. And we don't need to guess whether these were... Well, the Kowalskis need you to believe this is one set of photos, because if it's one set of photos, all taken at once, then they're saying you have no justification, you're photographing her for reasons, right? It's a different bed, it's a different time, because they know if you come to the conclusion, which is what the evidence, the overwhelming evidence shows, that these are two sets of photos taken at two different times, there's a reason for it, right? Whether it's a justifiable reason to take it without the shirt, with the sports bra, or whether they should have just enhanced. It's a reason. And we know there were two sets of photos taken because, again, we have a document of it. Defense Exhibit 3217-0850, 6:17 p.m. on January 6th. She's getting back, getting ready to take the picture. If you hear nothing from me, all is good. I'll lock the camera in my office over the weekend. Not a personal phone. It was done and locked in the office. And we know exactly when the photo was taken because it was taken between 6:17 p.m. and 7 p.m. when Miss Beatty documented that the photos were done. The pictures were taken with the help of the bedside nurse. With the help of the bedside nurse, and Maya wanted to pray. And in the last line, Miss Beatty went and got some grapes and cut red peppers from the cafeteria for Maya. Sometime between 6:17 and 7 p.m. on January 6th, the second set of photos were taken. But the Kowalskis want you to believe this is the second photo. With the sun pouring in. With the sun pouring in, long after sunset on January 6th. They need you to believe there's one set of photos. Because when we show you there's two, there was a reason why this was done. Again, Maya did not like the photos. I'm not trying to sell you that this was a pleasant experience for her. It wasn't. But you heard from Tashana Duncan, who saw her in court after the first photos were taken. Dr. Duncan said Maya never complained to her. Again, I'm not trying to minimize that Maya didn't like the photos, but she didn't go to the psychologist that day and say that she was traumatized by the photos. She didn't tell her uncle Scott. You heard his brief testimony on the last day trial of the defense case. He said she looked happy and normal. Talk about whether Maya had an advocate during her time at All Children's. Well, in addition to her parents, in addition to their attorneys, she had a guardian ad litem. And I think the guardian ad litem who was there only to advocate for Maya, answered a lot of the questions towards the end. She described Maya as a nice girl to talk to. She described her room set up with dolls, that she was happy, laughing, giggling. They went and played piano together. And she was asked, did you ever hear anyone at the hospital say anything bad about Mrs. Kowalski? No. You heard from Sylvia Ballwig on the last day of the defense case. Nurse Ballwig with the 1, 2, 3, 4, 5, 6 stars from the Care Journal. She loved Maya. 17 shifts. She talked about a religious relationship. She worked the EEG room. You think she would have left Maya in a filthy condition? Her? She loved Maya. You heard from Amanda Cook. And by the way, this is who All Children's is. It's these people with a healing touch. Nurse Cook talked about bringing the mission of Jesus to her work every day and bringing the healing touch of Christ to her parents, to her patients. She brought Maya gifts. Maya wrote a little heart behind her name. This is who All Children's is. This is who All Children's is. Lisa Reck, a bedside nurse, the spa days, the nail days, Halloween, helping her with Harley Quinn makeup. She brought her laundry home to make sure Maya had clean clothes. She was nominated by Maya for a Daisy Award. This is who All Children's is. This is who All Children's is. Does Maya look happy in these photos? They tried to make this awful experience as humane and comfortable for this child that they loved. This is who All Children's is. Not just these four. Not just these four. They all loved Maya. Look at the date. Shows you Maya's bravery and perseverance too, doesn't it? That even on January 9th, after she lost her mother, Maya took pen to paper and thanked Nurse Lindsay for her exceptional care in the hospital. Nominated her for the Daisy Award. That's who All Children's is. And this is who All Children's is. Maya Angelou has a beautiful quote about human nature that I live by. People will forget what you said, and they'll forget what you did, but they'll never forget how you made them feel. This is who All Children's is. People dedicated to try to make Maya's life in the hospital a little more comfortable than it needed to be. And that's the people I represent. Maya was discharged on January 13th from the hospital. I make a big deal about the medication sheet. It's in evidence. It's a lot. It looks like a lot, doesn't it? Aquaphor, a cream, an ointment, acetaminophen, Tylenol, vitamins, heartburn, the lisinoprostol is heartburn medication, albuterol for asthma. You know what's not on this list? No opioids, no narcotics, no ketamine. All Children's is proud of making sure Maya went home without these drugs. The judge at page 7 is going to give you his description in the jury instructions about Maya being released from shelter at this date. And at this point, Maya's with her parents and released from any other restrictions. Let's talk about experts. And I can't cover them all because I don't have time, and there were a lot of them, but I want to talk about a couple. This is an instruction that the judge is going to give you about the believability of witnesses. You want to talk about the intelligence of witnesses, but I want to focus you on the bottom part about the reasonableness of the testimony in light of your own experience and common sense. Because a lot of what you heard, we didn't need experts for. Some of it we did. Perhaps the most boring and confusing topic came from Jason Banger, who was the billing director of Billing Cycle. He talked about the DRG codes because the plaintiff made a huge deal of the fact that All Children's billed $500,000 for CRPS care, except what did he tell you? That it was all part of a DRG diagnostic-related group code. The pre-authorization was approved, and the entity that, if they didn't think we were providing the care for what we were billing for, was Aetna. They had 500,000 reasons to say, hey, guys, you're billing for CRPS along with all these other things, and you ain't providing the services. But what did he tell you? Every one of them was approved except $11. That's how meticulous Aetna was. They matched the services with what was being billed, And the reason is because what All Children's was providing was, as Mr. Banker told you, the primary driver was room and board and the therapies. And there's been no expert testimony to the contrary. We'll talk to you about Dr. Chopra. They brought him in. Again, no hospital privileges. It's a pattern. He told you ketamine's non-addictive, no nausea, no problems. I believe that was contradicted by Dr. Barr. But he told you something super important. Super important. CRPS is a lifelong condition that never goes away, right? If that's true, why on earth does All Children's Hospital owe $10 million for future care for CRPS? We didn't cause it, if she has it. You heard from Dr. Elliot Crane. CRPS, no known cause, rare and regional, thus the name chronic regional pain syndrome. Takes years to spread. Although, in fairness to Dr. Chopra, when he came back, he did say, in his cases of seeing whole body CRPS, it takes some time to spread, not 72 hours. But he told you the foundation of treatment, the evidence-based medicine of treatment, physical therapy, occupational therapy, cognitive behavioral therapy, and if needed, occasional medicines for breakthrough pain. He told you that what he saw from Dr. Hanna was 10 times the anesthetic dose. 10 times the anesthetic dose, what they would give you if they were going to knock you out and take out your appendix. And he ultimately told you that All Children's complied with the standard of care. He did that in support of fine doctors like Dr. Richard Elliott, who testified to what Mr. Hunter told you at the start of this case, that the treatment for CRPS and conversion disorder is the same. It's get you out of the wheelchair and let's get you functional. Let's get you moving. He testified that Dr. Hanna's doses were infinitely higher than what All Children's recommended. He also told you that CRPS is not associated with the gastroparesis, the constipation, the food not moving through. Because it doesn't matter what the diagnosis is, the treatment is what matters. This is the treatment that was recommended way back over a year ago at Lurie Children's, Tampa General. It's the same. And so when you're answering the question on standard of care, and it's in the judge's instructions, reasonable care is the part of a healthcare provider which, in light of relevant and surrounding circumstances, is recognized as acceptable and appropriate by similar and reasonable careful healthcare providers. Well, we provided you this, but the list is much bigger. The list is much bigger. This is what we mean when we talk about an instruction of what do similar healthcare providers recommend. Had this course of treatment been followed back in 2015, we wouldn't have been here. The judge has instructed you that stress from the lawsuit is not a matter for which you can award recovery. Okay, this has been a stressful process for everybody. I get it. It's very natural. The 2020 hospitalization, this is at Joint Exhibit 1030, 0014. Okay? Maya Kowalski went to the hospital for what they claim was a relapse. If you look at the records for what this was, it was a recent episode of epigastric abdominal pain, decreased appetite, and the assessment was a 14-year-old female with significant weight loss likely related to stress. The musculoskeletal exam, no joint swelling, no limb deformity, no rashes, no lesions, no jaundice. This concept of All Children's cause some type of relapse, the only evidence in this case of any hospital visit in that period of time, other than a broken finger, which they're obviously not claiming was the fault of anybody, for which she sought medical care, I believe, 48 hours after the injury. Other than that, the only hospitalization was related to stress. So when we talk about causation, for the plaintiff, they first have to prove on medical malpractice we were negligent, and we believe the overwhelming evidence is that All Children's practiced the evidence-based medicine that was proven to work at multiple institutions. But they have to do what is in your jury instructions as the but-for instruction, right? Makes sense. They have to be able to tell you that had it not been for all children's, Maya would have been better. They brought Dr. Bifulco. And if you check your notes and if you were listening carefully, Dr. Bifulco made 3 critical concessions that, from the defense's standpoint, cannot support any verdict against All Children's Hospital on medical malpractice. Not just because we didn't commit medical malpractice, but because he was asked directly. And he could not testify what Maya was going to need but for her All Children's hospitalization. He could not testify as what she would need from a psychological standpoint, but for All Children's. He made no determination about what she needed. He was just saying, she's got CRPS, this is what she needs. Dr. Chopra told you it's a lifetime condition if she has it. And then, at the bottom, he made the recommendation for $3.7 million in ketamine, and I said, Dr. Bifulco, where is that coming from? Dr. Kirkpatrick. Why are we going backwards? Why would we, with all of the progress that Maya's made, her bravery, right? I mean, truly, in the face of tragedy and losing her mom and going home, and through, the shepherding of Mr. Kowalski to help get her healthy, we'll talk about that a little more, why are we going back on ketamine? Do not award millions of dollars for ketamine. Dr. Levy was brought to answer that question. She is the director of adolescence and substance abuse addiction at Harvard. You didn't need to hear from her about whether ketamine can cause hallucinations and mood disturbance. You heard it from Beata. You didn't need to hear from her about the short-term memory issues. You heard it from Beata. But she told you what would happen to the developing brain if you started exposing it to ketamine again and again and again, as in Dr. Bifulco's life care plan recommended by Dr. Kirkpatrick at $12,000 for a week. It would cause addiction problems and potential neurotoxicity. And by the way, when we talk about memory disturbances, if you look back at what they are alleging at All Children's Hospital, and this is really important, almost everything, if not everything, that they're alleging against Miss Beatty is based on Maya's memory, isn't it? I mean, Mr. Kowalski testified that he didn't personally observe anything untoward. The people who came into the hospital, whether it was the teacher or the guardian ad litem or the people that are not affiliated with the hospital, no one saw anything. It's all based on the memories of a 9 to 10-year-old child in the hospital who, by her own admission, was, when she disclaimed the care book, told you I would say anything I needed to get out, including telling these nurses that I liked them, even though I didn't like them, which is understandable. Who would want to be in the hospital away from their family? But that's what it was based on. Those memories from that time. I'm going to handle a topic as sensitively as I can. The plaintiffs called an expert, Dr. Scott Richards. We had a little bit of fun, right? Maybe it wasn't fun, but you were Mr. Anderson's frat brother, swim teammate, and he told me, well, we listened to different music. We were in different parts of the frat. But he's the sacrifice he's talking about. When I tell you, when you listen to experts and you can use your common sense, right? It doesn't go out the window. The suicide, for better or for worse, was a result, was it not? Doesn't your common sense tell you about her being separated from Maya, for which this hospital is not responsible? You don't need an expert, especially someone who's never evaluated Beata. When you're looking at the instruction, when they're trying to hold my client liable for a suicide, when all we were trying to do was protect Maya, when all we were trying to do was provide evidence-based approaches for therapies that we believed could heal her, what was the extreme and outrageous conduct that they proved through their burden that All Children's did? What was it? When you're back in the deliberation room, what was it? The phone call that was Charlotte Laporte, the confiscation of communion that was Tori Nias, having a child on your lap. a factor that can be used to say suicide? The uncontrollable impulse, and because there's family here, I'm going to be brief. You've seen how that act was carried out, and it wasn't instant in terms of the setup. But there's notes, and the most important one is the one that's at Exhibit 3212. Beata Kowalski, moments after the judge denied her the right to hug her child. We're not here to argue about the dependency court. It's a separate issue. Okay? This note was penned now, what, 3.5 months? I think the plaintiff said 99 days or 107 days after no contact with her daughter. It's not from placing a child on her lap. The letters to the judge. Oh, and by the way, the response at the end. I hope you will take responsibility for my daughter's physical conditioning, worsening of her CRPS that will eventually lead to her slow and painful death. Where'd you get that? Remember? Remember? Dr. Kirkpatrick. Who put that idea in her mind? Not all children's. And by the way, he tried to backpedal, didn't he? Pulmonary embolus? You know what that is. Gone. That's not what he's talking about. Put in Mrs. Kowalski's mind that if she didn't get his ketamine, this would happen. Shame. And then the final note that was now written, this one's now, if you look, just in terms of the time, and I don't want to belabor this point any more than I have or I need to. January 6th, 3:57. Now we're to January 7th at 10:59. 30 plus hours have passed. This is not an irresistible impulse. I need to talk to you about damages, and I'm going to do it briefly. All Children's would not be here if we thought we owed the damages in this case. Okay?
Mr. Shapiro, you've consumed an hour and a half.
Thank you. But I told you in voir dire, we don't argue damages in separate sections. We don't see if you award liability and come back. We do it all in one part for your efficiency. If you don't agree with me, here's what I would suggest. For medical malpractice, the only thing that Maya would need is a tune-up on physical therapy. You heard from Dr. I don't know if it was Ms. Kirby pricing it out. You can use your common sense. If physical therapy costs $150 a session and she needs another year of it and needs it twice a week, $300 a week times 50 weeks would be $15,000. That would, if you really believe we interrupted her care by not giving her the ketamine and we're somehow liable for medical malpractice, that would be what would be reasonable. I want to talk about the photos because this is important because I know you guys are going to wrestle with this. I get it. You have the batteries were either 2 days in a room, same room as anything else, or we have Maya's shirt being lifted and being taken photos, 10 minutes, 15 minutes on the front end, 10 minutes, 15 minutes on the back end. If you don't like it and you disagree with me and believe she owed some money for that, then you should award something for that. And the judge's instructions, in the instructions, give instructions, and don't rely on this, because these are different instructions for medical malpractice, but the general verbiage are awards should be fair and just in light of the evidence. Awards should fairly adequately compensate for the loss. They're compensation damages for that. If you believe because of the photos that Maya Kowalski needs therapy, and by the way, we think she does too. Anybody who lost their mother in this circumstance believed that she would benefit from psychotherapy. Whether we are responsible for any of it or responsible for part of it, then award it. You heard from Ms. Kirby that inpatient therapy is $30,000 to $57,000 if you think that she needs psychotherapy for the next period of time. You know, if it's $100 twice a week, if you think that it would take $200,000 in therapy, or you want to award $250,000, those are numbers that are realistic. That's real money. And finally, I'll just talk to you about the unfortunate act of suicide. And I want to tell you that there's the numbers they've put on the board. We have to tie it to real money, not monopoly money. These would be real dollars, written checks to the Kowalskis. If you think we're really liable for a suicide, that we would suggest that numbers from $500,000 to $1 million or $1.5 million, even per person, would be something that would be fair and adequate to compensate for the situation if you owe it. And in terms of totals, whether that's 3 million or 4 million, I think that would be more than fair. But I do want to talk to you face to face about this, because that is a charge that All Children's is here to absolutely deny. We did not do anything that caused extreme emotional distress. The idea that this hospital system engaged in some system-wide conspiracy to try to aggravate Beata when all we were trying to do was get Maya on the correct course. On those boxes where you are required to find outrageous conduct that pushed her to that, I implore you to check the box now. I'm going to touch on this and then we're going to move forward, because almost all of these damages are this idea that Maya was doing wonderfully well before and now she's in a bad spot. And that's why I spent a lot of time going through the previous history to show the quality of life of zero, the ketamine comas, the short-term memory problem. We got into it, right? Me and Mr. Trump, about the freight train heading to college. And his insinuation that the unfortunate, not her fault, right? Mine was none. The comas, the treatments, the memory, the hallucinations, the quality of life of zero. That's what we inherited. Where's she now? How are we liable for future vocational losses? How would All Children's, use your common sense, how would we be liable for any of those catastrophic numbers when, because of the care and treatment, and because of Maya's perseverance, as shepherded by her father, we saw this, May 26th. This is now a little more than 4 months after getting out of All Children's. How are we liable for worsening a condition? Let's hear what Dr. Hannah said. She went back to him. Joint Exhibit 1040, number 7. This is on June 8th, so what is this? February, March, April, May, June. 5 months after she gets out of All Children's. This decrepit condition we left her in, not a drop of ketamine, right? Let's look at it. Overall, the patient has had 60 to 70% relief since his last visit. What is he comparing to? October 6th, quality of life of zero, and now, through the therapies of All Children's and the dedication of Maya working with Rachel DeYoung, her outpatient therapist, only warm water therapy and physical therapy, she's got 60 to 70% relief. Look at the next box. Negative allodynia, negative hyperesthesia, negative hypersensitivity, negative, 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 negative. What's she doing? Patient reports no hypersensitivity or allodynia. She's doing pool therapy and physical therapy twice a week. That's their doctor. Let's fast forward to July 6th. Agility Physical Therapy. Less than 6 months after she gets out of All Children's, off the ketamine, off the drugs. Patient and father state the patient went swimming in the ocean over the weekend. Mr. Kowalski reports that Maya has a new bedroom set with a bunk bed on the top and is able to get up and down the ladder without help. August 14th, back to school. First time in 2 years. August 22nd, last day of physical therapy. September 5th, back to Dr. Wassner. You want to know what he said? Let's look. Maya's doing markedly better. She's been able to get out of her wheelchair and goes to school full-time with use of her crutches. Father is extremely pleased with her progress. She has not had any recent asthma flares. This is what we mean by progress. October 20th, 2017. (2018, 2019 is easy because we heard from Mr. Kowalski. We played his deposition for you on November 6, 2019. Now, Maya is the president of the Honor Society, president of the chorus, class president, followed by Duke Tip. And what was his sworn testimony to you? No evident signs of CRPS, no complaints of pain, and no signs of lesions. What did we complicate? Or what did we help Maya get on the path to? Recovery. I have nothing to fill in here. Thank God. Maya testified she was proud of her progress, as she should be. 8th grade picked PE as an elective, participating in all school sports. She told you 6th grade, 7th grade, 8th grade, no flare-ups, and she talked about a daily routine that should be the envy of any healthy child. 5.5-mile running routine, high interval intensity training. What about the medications? Flonase and Claritin only. Had not touched narcotic pain medicine since she left All Children's. That's the dream we had for Maya. And then I had a chance to talk with Maya again on March 22nd, 2022. Claritin and sleeping pills only. Still playing piano, still ice skating, lifting weights, cardio, bike rides. She made a statement that she should be very proud of, that she told you under oath that her pain is better now than it was in 2015 or 2016. She's able to get back on the ice. And able to get to the point where she's able to enjoy milestones. Healthy milestones, something people dreamt for her. Homecoming 2022, being able to be in a limousine to go to Homecoming 2023 during the trial. And from what I can tell, in the photo on the right, Maya looks happy. I'm asking for your verdict, and I'll tell you why. One of the most unfortunate parts of this case is the caption. Kowalski's versus All Children's. We were never against the Kowalski family. We were never against the Kowalski family. The reason why All Children's did what it did, the reason why All Children's tried to comfort Maya, the reason why All Children's tried to get her on a safe medical path is because the loving and caring providers at my client's hospital believed in a better future for her if they could get her off the unnecessary drugs given at dangerous levels. Period, end of story. And time can tell, right? Sometimes we can tell whether they were right or whether they were wrong. On all of these counts, false imprisonment, whether there's any clear and convincing evidence of any punitive damages, and if you think there's an element in this case where she deserves compensation, then that's what you're here for on one of these counts. We disagree. There's nothing outrageous that the hospital ever did. There's no reason to be considering punitive damages. Your work can end with your deliberations. We don't need to come back if you believe you can fairly and adequately compensate the Kowalskis, specifically Maya, if you believe there's anything else. And that's important on all these counts, because you know what we really need in this courtroom is closure for everybody. Now, I don't get another chance to talk to you. That's, as the judge told you, and I'm almost out of time, that it's normal, right? But I want you to have this in your mind when either Mr. Anderson or Mr. Whitney come back and talk. and they're talking to you about this aggravation of pre-existing injury, what would Shapiro say? Well, she had it before. If they're talking about violations of rights, well, what would Shapiro say? Well, when and who? If they're talking to you about, here's what Kathy Beatty did, what would Shapiro say? Well, what's your evidence of this? What evidence do you have of this that you're accusing my client's children's hospital? At the bottom of your form, after you complete the verdict form, and it's long, after you complete your services juries, for which we all in this courtroom tremendously thank you for, you're going to date and sign this. This has been a long process for you. It's been even a longer process for the Kowalskis and my client. It is time to bring closure to this phase. I would ask that your verdict be fair and just. I would ask for it to be in my client. And when you do it, be proud of your verdict, that you're bringing justice to the Venice County Courthouse, to the Sarasota County Courthouse, so that everyone can go home and heal and rest. I thank you so much for your service, and I thank you for listening.
Let me complete your closing arguments, Mr. Shapiro.
Yes, Your Honor.
Members of the jury, we're going to take a 10-minute break. What's going to happen next is the plaintiffs will come back for their rebuttal arguments, and then I'm going to talk with you some more, and you'll be able to, at that point, begin your deliberations. So you're still an hour and 15 minutes away from that. 10 minutes, do not discuss this case amongst yourselves, do not do any investigation, and receive no information.
All rise. Jurors exit.
Out of our presence, any issues we need to address before we take our break?
Yes, Your Honor, we should probably approach on it.
before we bring the jury back, let's go over a few things.
I've got the flash drive with the list. Do we have the 6 copies of the Excel spreadsheet?
We're working on that now, Judge Bridgman.
So, Alex, can I give this to you? Okay, so that will go back with the jury. I saw that both sides were working with the clerk for an hour and a half this morning on exhibits. Do we now agree that all of the exhibits are correct and there's nothing wrong with any of the exhibits? Or do we still need more work on them?
I'm told we have one exhibit for printing versus using reports. 2819A is being printed currently.
And how much longer is that going to be?
Less than 10 minutes.
So besides that one issue, everything else is okay?
Yes, Your Honor.
And there's nothing inappropriate with any of the exhibits, and there's nothing, no unauthorized material or anything like that. Is that correct? And Alex, do we have everything on
Both
Part-
plaintiffs and defense looked through the exhibits.
So we have everything on a cart ready to go?
We have 2 cards.
2 carts, okay.
Same.
Now, if the jury wishes to end at some point this evening without a verdict, the plan of action is going to be as follows. I have an envelope, and what we're going to do is we're going to have the jurors put the verdict form in the envelope. They will then initial, when I say initial, they'll put their juror numbers on it, and then we'll bring them in. We'll hand it to the clerk. The clerk will run tape over the seal, and the clerk will maintain the verdict form in this envelope. There's nothing in the envelope. It's just an envelope. So is that procedure acceptable for everybody?
Yes, Your Honor, for plaintiff.
That's fine with defense.
After the plaintiff's rebuttal closing arguments, the first thing I'm going to do with the jury is I'm going to make those 3 corrections in the jury packet. I'm just going to have them write it on there, and then I'm going to discharge the alternates. What I intend on doing is have the 6 jurors who are going to deliberate stay. I'm going to have the 5 alternates that will be discharged go back and collect their materials, and then I need the sheriff's office to transport them off-site. When they are out of the building, can you radio back so we can then let the jury begin to deliberate?
Yes, sir.
Okay, but the moment I discharge them, I can't have those 2 groups interacting with each other anymore. Any questions about what we're going to do and how this is going to go down as soon as the plaintiff's rebuttal is over?
No questions, Your Honor.
No questions, Your Honor.
Okay, let's bring back the jury.
Rise, jurors entering.
Okay, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation, and you did not receive any information about this case. Is that correct? Correct. And no one's approached you about this case. Is that correct? Correct. And you've not seen any media coverage about this case. Is that correct? Correct. Now, my fault. I forgot to tell you before you went on that last break that that's going to be your last opportunity to make a telephone call before you start deliberations. Is there anyone on this jury that needs to take a couple of moments to make any last-minute telephone call, because effectively this will be your last opportunity until the time that you go home today. So does anyone need, and I apologize for not reminding you about that. Okay, it looks like we're fine. So, Mr. Anderson, you have the floor.
Please, the court. What you heard was exactly why we need punitive damages in this case. They still don't get it. Well, I think I heard that they agree with some of our liability positions. They still do not understand institutionally, as voiced through their attorneys, how awful this was, how terrible it was, the things that they did here. This is Johns Hopkins. This is Johns Hopkins All Children's Hospital. This is who they really are. This is a place where they call little girls who just lost their mom ketamine girl, and appear to have absolutely no problem with the fact that they knew this was coming and said nothing and did nothing. This is who Johns Hopkins is. They say, I wouldn't put anything past her mother. Put what past her mother? Trying to take care of her child? She can't perform this charade effectively 24/7. They're talking about a 10-year-old. Maya feels we, ACH, is lying. Wonder why that is. What kind of doctor-patient relationship is that? What kind of pediatric relationship is that? Why would you want to keep a child there when the child doesn't want to be there and just wants to be away from you in this first week? Maya feels we, J or ACH, is lying to her about her mother, that the doctors are lying about her parents. This should never even begin to start up in a pediatrician-child relationship. It should never, ever be. This is who Johns Hopkins All Children's Hospital is. It's a place that retaliates against its own employees for bringing things out that are negative, and retaliates against anyone, any parent, who decides they want to do something different. All I heard on the other side was, it's our standard of care. It's our standard of care. It's our standard of care. Who cares if it's your standard of care? A parent has a right to decide their child's own treatment. They don't get to choose it. And that's a lot about what this case is about. It's about an organization that is so screwed up that it actually thinks it's a good idea to force parents to accept their way of doing things. And if the parents don't, then they've got to find different ways to punish them. That's where all this stuff came out of on the 7th. They disagreed. Beata, a registered nurse, an infusion nurse, knew what she was talking about and had 15, 16 months of experience as to what worked and didn't work, made the greatest mistake you could ever make to these people. She said no. They still don't freaking get it. They still don't freaking get it. Here are the punitive damages questions. 5, 10, 15, 20. Those are 4 opportunities, if you agree with the plaintiffs, that this is completely and utterly intolerable. Punitive damages are for willful, wanton, and malicious character, behavior. There's absolutely no question that risk management, with the concurrence and knowledge of the General Counsel, which is as high as you can get in this, planned and instituted this entire idea of stripping this child down, taking photographs of her, not letting the parents know, against the child's will. They knew it. They instituted this from the very top of this organization. What does that tell you about what's going on here? What kind of ultimate lack of humanity? There needs to be some captain of this ship, and there never was. It was totally dysfunctional, the way this hospital operated. No one was checking. No one was making sure to see how this child was being taken care of. No one was looking to see how their own employees were behaving. And it wasn't just one. Yes, it has to be clear and convincing, but when you have internal memoranda from the highest up in the hospital down to a Kathy Beattie telling her to do something like that, that's clear and convincing. That's from the highest part of the hospital down to do something despicable. You don't do that. I heard a lot about attacking Beata. I never figured out why. If they really... Okay, again, pardon me if I'm confused on this. If these doctors, who are all licensed and specialists in CRPS and pain control, prescribed what they think was too much medication, why go after mom? Why not go after the doctors? Where have you seen anywhere where anything that Johns Hopkins did questioned the actual doctors writing the prescriptions? No, it's too hard. That's too hard. That might cause problems. Now, it's easier to go after Beata. Plus, she insulted them by not agreeing with what their routine was. Think about this, though. If the whole point here is that Beata, who is just trying to take care of her child, by the way, is taking her child to places and trying to get treatment, and these doctors are prescribing all of these excess medications, or this won't work, or that won't work, why are you attacking the mother? What possible good does that do? After the Mexico trip, one of their pulmonologists, who actually was a very nice man, Dr. Kreisman, saw Maya, having seen her 2 times before Mexico, and now 5 months after Mexico, and says, talking about the treatment in Mexico, the long-term ketamine infusions, this is a new child. Do we have that? This is a new child. She's bright. She no longer appears to be in pain. On physical examination, she's examined in her wheelchair. She is a completely different child from the last exam, which was 2 months before Mexico. By that I mean she is not in any pain. She is not moaning. She is smiling. She is interactive. She is very engaged. Oxygen saturation is 100%. Weight 25 kilograms. This is an experienced Johns Hopkins doctor. Remember I said there's a lot of the outside doctors I thought were trying to do their job. Apparently Dr. Kreisman was. And 5 months after, here he is saying this is a different child. That's their own physician saying that. And please keep in mind, around this time, their surgeons also put the port into her chest to facilitate the ketamine infusions. What you are seeing here is an incredible example of revisionist history, picking little bits and pieces out of the record and trying to fashion them into some blame. What did the Kowalskis do wrong here? What was the purpose of all this? Other than arrogance and the belief that ultimately they could get away with it. Forcing the parents to agree with your own version when you don't even have the doctors with the right specific skill set to disagree reeks of arrogance. It reeks of people who are not getting out enough medically, who are not keeping up with the latest trends. If they're going to be Johns Hopkins All Children's Hospital, which is supposed to be the Johns Hopkins name, one would think that they would be right on top of the very latest treatments, right? They weren't. And they relied on this Sally Smith character to come in, and she's a pediatrician, and there's nothing against pediatricians. I'm not down on pediatricians. I'm down on pediatricians who think that they're neurologists or anesthesiologists with a subspecialty in CRPS and a subspecialty in ketamine treatment and treatment for what is known as chronic CRPS. See, Maya had already been through all of those things that Johns Hopkins was suggesting, and Beata knew it. Beata knew the only thing they had within that first few hours they were questioning them. That's why tensions were getting a little high. Are you going to be able to increase the amount of ketamine for my kid or not? No? We're out of here. Oh, wait a second now. This might be dangerous. There might be something wrong here. Now, we want to leave. Okay. Well, just let us hold on for a second and we'll see what we can do. Ask yourself this. Where were their psychiatrists? They brought in little bits and pieces of other hospitals, psychiatrists, or in one case, a nurse's assistant, pediatric physician's assistant, who's a nurse, to make a diagnosis or a potential diagnosis. And they brought in another instance, a nurse in another hospital who thinks this might be conversion disorder. Ladies and gentlemen, where did you see their expert come in and confirm any diagnosis of conversion disorder or any psychosomatic condition that outweighed that it was CRPS? They're Johns Hopkins. They can't find a psychiatrist to come in and agree with them? Nope. Attacking Beata. Why go after Beata? I guess it was easy pickings. I guess they figured, I don't know whether it was her accent or just the way she acted or what it was, but they sure did hone down on her. I can't put anything past her mother. I'm trying to, and have tried to, through this case, use videos and photographs to try to express to you how the child was doing at different stages, because I believed that you would trust your eyes. You would trust what you could see and watch. And that's still true for after she got out of there. It still took her 10 months to get back to even close to a baseline, and another 6 months of transitioning off to get off of those crutches. And she did it through hard work. And instead of it being looked at as a good thing, this is a sign somehow that they're right. They're actually taking credit for all of the incredible hard work Maya did on her own. And we all pretty much know why she was doing this. She wanted to prove something. She wanted to prove to them she could do it. It hurt like hell. She had no ketamine, no pain meds, scared out of her wits, the family. And when you read there those orders, you'll see that for the last 10 days to 12 days, the judge said, and no ketamine. Do you really think that this family was going to go back and try the ketamine that put them right back there in that power system? You think they're really going to go back to that? No. And that's why they didn't go back on the ketamine. The ketamine worked. It would have made her life so much easier. But Johns Hopkins, they ended that. You know, in the Civil War, they would cut off soldiers' arms and legs with a shot of whiskey as the anesthetic. That didn't make it good. That didn't make it state of the art. That's just all they had back then. The ketamine was there to help her get better and to help her reach the best that she could be. And they took that tool away from her.
Your Honor, I object. This is immunity issues.
Sustained.
think of it this way. They believed, I gather, that Maya had recovered because of their treatment. What she did was have a remission. And we've spent the past 8 weeks explaining CRPS to you. It's a devilish disease. And you can go for months, weeks, months, years, you can have a change like that. Exactly what happened in November of 2020, and then again in 2022. And think about this. This is during the period of her life where her immune system is at its absolute best. What's going to happen when life starts to take a few chunks out of her? It's not a very good thought, but she's brave, so I think she'll get through it. But it's going to be a lot harder on her, and it shouldn't be, because let me get to a point on this causation thing that the defense was talking about.
We've consumed an hour and a half total.
Say it again, Your Honor.
An hour and a half total we've consumed. 30 minutes left.
Thank you, Judge. In your jury instructions, you will see an instruction on causation. And what it's going to say is that it doesn't have to be the only cause for you to award damage. It has to be one of the causes, and in the terms of suicide, a substantial cause. So you can have two forces acting and still award damages for it. And if it is the aggravation of a pre-existing condition, which in this instance would be the CRPS, you can look at the way she was before, and then you can look at after the tortfeasor, in this case Johns Hopkins, aggravated it, to see how she was after. Now here's the key. You can divide that up if you have the evidence to do so. Typically the evidence is where a doctor comes in, qualified physician, and says, okay, 50% of this, 60% of this is pre-existing CRPS, and 40% of this is the aggravation part. You don't have that evidence here. You don't have that testimony in the record. Under the instructions you have, then, whatever CRPS she had before it was complicated with PTSD, depression, and a failure for the first round of treatment to succeed, whatever that ended up to be, unless you can find a way to divide it up without medical testimony, 100% of what she ends up with is on them.
The judge is a misstatement of the jury.
It's not.
Overruled.
So, when you're considering back there, well, she did have CRPS beforehand, and that's a difficult disease, and I don't know if we can really blame Johns Hopkins. Well, you can't blame him for her having CRPS walking in, but you darn sure can for what happened walking out. And the fact is that with the post-traumatic stress disorder, absolutely, I don't want to say earned, but imposed on her, and the depression from a variety of factors, not the least of which is losing her mother, that aggravated it and will continue to aggravate it down the road. And here's the problem. What you've seen in the November of 2020 relapse was because of a psychological factor. That's what triggered it. That was not a physical factor. When she had the relapse, right before she went in during October of 2016, that was a psychological factor. So you have what's known as a clinical history of psychological factors aggravating her CRPS, right? You had the CRPS, and now you've got an overlay of a CRPS that has been complicated because the first round of treatment was not completed. The glial cells that Dr. Chopra talked about, that was not completed. That made her more susceptible to longer, more intense, more frequent of these relapses. And then you had an overlay on it of psychological issues, not her own, caused by them, that are going to aggravate her situation the rest of her life. And like I said, she's at the top of her game now biochemically. Wait till you get out in the real world and you start to age a little bit, and you start to have some things, life take bites out of you here and there. You're going to have some psychological issues come up. And she's not going to be as equipped to deal with them as she could have been. Because Beata had a good plan. Beata had figured out, very smart lady, how to deal with this. And although Maya would much prefer never to have this loathsome condition, her mom had figured out how to allow her to be the best she could be. Now that was taken from her. And so when you are back there considering the damages, I want you to consider, from Maya's perspective, how great she can be, could be, with the talent she has, her intelligence, her abilities. But to get there, what kind of stresses is she going to have to put herself through in order to get there? And then, from there, how is her aggravated illness going to react? This child hasn't even taken her SATs. She's in halfway through her senior year in high school. She hasn't applied to any universities. Yeah, back in 2019, she's ready to rock. She's ready to go. Life has a funny way of affecting you, doesn't it? And after you start thinking about what you went through and you start having a relapse, you lose a little bit of initiative, a little bit of drive. If she does overcome that, though, if she does try, think about the psychological challenges of going to the type of school that she should, by all rights, go to, a top university. Think about the challenges she faces in the type of jobs that she should be able to do. That's where those big numbers come from. And they're not made up at all in any way. And I tell you how I know. If they had their own Dr. Bifulco, life care planner, where was it? No psychiatrist? No life care planner? If they had their own Dr. Tremp talking about the Freightway to college, which is what he was talking about before all this happened to her, if they had their own Dr. Tremp, where is he? If they had their own economist to figure this out, where is she? Or him? With the kind of defense they put together, if there was somebody who truly was going to disagree with those numbers, don't you think they'd be in here testifying about it? Instead of having their lawyer come in and attempt to pick here and there at the sidelines of what really happened to this family. And it's not just Kathy Beatty or Sally Smith or some of those nurses, and there were some good nurses there. I'll talk about that in a moment, but this was a problem endemic to the entire operation, and that's why they were in imminent jeopardy, IG, of losing their accreditation to be able to continue to receive federal funding and get approval from the agency that was overarching all hospitals, the industry leader there. This was an organization that was teetering and was trying to get its act together because its culture of people reporting problems was so toxic that they had to have multiple meetings and consultants and ideas of just how to fix it. And all that came well after the poor Kowalski family was involved. This went straight to the top. This ship never had a captain. And that's how you end up with these situations. It was a totally dysfunctional organization, and the Kowalskis paid the price. we didn't take. Nick did a great job, didn't he, on the numbers? I'm not so hot on the numbers, as we know, but they tried to minimize some of the effects of this. They tried to talk things down like, well, it was only 15 minutes that she was pinned down, stripped, photographed against her will. This is a 10-year-old girl. She's ill. She has a disease that will not allow her to escape in any way. She's in a wheelchair. She's in a place that she despises, around people she doesn't trust. And she's being photographed naked. And the way you know that is the other nurse came in and testified. Do we recall? Alcia Aishi? I've got her name here. The other nurse that's seen in the picture. And she said, yes, Maya was stripped. Maya was naked. Yes, we did hold her down. And Beatty...
Characterization of the evidence. Overruled.
And we also know, because you saw the deposition testimony of Kathy Beatty, in which she said, unfortunately, we did. That's not something you say if you're particularly proud of what went on. Which begs the issue, then, if Ms. Beatty is willing, if you believed the other nurse, who frankly did not seem capable to me of misrepresenting anything, if you believed the other nurse that in fact Maya was stripped down, and if you believe that she was confirming what Maya testified to, and they never caught Maya in a single inconsistency in her depositions, did they? Not once. If you believe those two, that means that Kathy Beatty was willing to get in here in front of you and completely and utterly misrepresent a key fact in the case. How reliable is that testimony as to anything she has to say? Or was this the type of person getting caught who's willing to say almost anything to get themselves out of it, or what they perceive out of it? And for Jack, again, I apologize to him for him ever having to hear Detective Graham's voice again. Lord knows that's traumatizing enough for him. Detective Graham's techniques in attempting to flip Jack by telling him, among other things, that I'll put you away for 20 years if I think you're harming that child, and trying to get him to say things against his own wife, were completely and utterly despicable. Jack was faced with a circumstance where, if he didn't cooperate with this lady, he truly feared, A, he could go to jail, B, that they were going to work some way to make sure Maya never got out of there. And even then, he did his best to protect his wife. But you know what? It did have an effect. It did have an effect, because it drove a wedge between Beata and Jack. It caused Jack to question the actions of his wife. And by the end, when you read those suicide notes, you'll see, for instance, that Beata actually gave the rights to her parental rights to her sister. By the end, and this gets into what happened with Beata, even her marriage to her appeared to be brittle and with problems. Child is away from her. She believes her child to be in desperate trouble. She believes that her child could end up as another CRPS fatality. She believes that her husband, while loving her, there's a rift. She feels isolated. She feels alone. And she is motivated internally by about the strongest urge, the maternal instinct, that we know, even in all mammals, let alone human beings. when you're looking to see whether you should check yes, that it was what Johns Hopkins did, whether they were a substantial factor or that she acted on an impulse, please consider how powerful the maternal instinct is.
You have 15 minutes.
But I don't think these folks here get it. I still don't think they get it. Okay. Let's play then 2695. This was a mom who loved her daughter. What I found interesting also while we're looking at it is that the defense took...
Hold on a second. Is your video monitors not working? Okay,
Mr. Reyes, I'm going to turn it off and turn it back on, see if that cycles it. Is it there now?
That's it, no?
Let me try this.
No.
Did it come on now?
Well,
Is it there now? Mr. Reyes, I'm going to turn it over to the left table. We'll try that. And Mr. Anderson, I'll give you a couple extra minutes.
thank you, Your Honor. Just a note while we're waiting here, check out Exhibit 3115, which was that recording with Beatty jumping in, and then compare it to their recording about can't talk, or the recording about can't talk about the case. It was Kathy Beatty. No, if we can play 2695, is that like we're not going to be able to do it? What I'm trying to show here is two things. First, the relationship here between mother and daughter, and a little bit about what each of them lost.
That's better. I love you.
Can you see it?
You can see that.
All right.
Now go down
Got a
slowly.
big one.
Go down slowly. Good job. Good job. Very good. Excellent.
Is she supposed to still be faking there? I'm losing my timeline on whether or not they think Maya had CRPS or not. Playing piano for my mom. I don't think I'm going to try to go through every single tidbit that they pulled out. I go back to, again, when I thought when I woke up at 1:30, which is I've been in the same courtroom with all y'all. So we all heard the evidence, and you all wrote a novel for about every witness. So I have great confidence that you will put everything they said into the perspective of things. One thing that really upset me was this idea that when she was in room 709, she could either escape or it wasn't that big of a deal. Somehow I believe that having to defecate on yourself is a pretty big deal. And if she couldn't get a nurse in to even help her over to the commode, it is really difficult to believe how Maya would be able to escape that room. I think that what we're dealing with here are a number of attempts to just pick at the edges of what was going on. I don't think they've rebutted anything that we've said. They've come in and tried to show you inconsistencies. But here's the thing about human beings and trying to recreate history this long ago back. This family's been seeking justice for 5 years now, 7 years since this happened. Pretty brave family. And you're never going to have everybody agree on everything. Moreover, if you did, such as what I think happened with a lot of the defense's witness, they sounded remarkably the same in a lot of things they were saying. I don't think that's a good thing. I think that as jurors, you're able to tell when another human being is being candid with you, frank with you, and really trying to tell you what's going on, or when they're telling you something they are trying to get you to believe and talk you into something. I brought in as many live witnesses as I could because I believed each one of you would prefer to have the human being here in front of you so that you could judge for yourself all of their different reactions to things, so that you would be able to know when somebody was just not comfortable or not. And the nurses at the end, yeah, some of them were nice, but some of them just seemed like they were trying a little too hard. The shockness thing drove me freaking nuts. And so I just don't think it was effective to have people come in with sort of a canned speech about this. Because I kept saying to myself, if you cared so much for this child, where were you? She had to be trying to express some things. What Maya said, and it's pretty smart for a 10, 11-year-old, she thought, look, maybe if I'm super nice, they'll let me out of here. That's why she was going through all these things. We're talking about a child who's trying to survive in a very bad place. She's trying.
I'm sorry, did the video monitors come back on? Now they're on. I apologize.
It's okay, Judge. And in the end there, I thought with putting up the photographs of Maya just trying to go out for an hour at her homecoming, I don't know what they're trying to say there. Is that evidence she's somehow fine? Maya waits to the end of the day before picking a dress, not knowing if she could even go because of where her pain was in. And she didn't have her mom for this important rite of passage. No mom, daughter prom shopping, no pre-prom makeup, no nail sessions with mom, no mom for the excitement of pre-prom photographs. And after it's all over, she comes in here and sees that they've found on somebody else's, a friend's, social media, a picture of her. I don't understand the relevance of that. Did they not hear through all of this that this disease is such that you can have a wonderful day and then have 4 bad days and then 2 weeks or maybe a month of a great relief, only a 2 or 3, and then end up with 4 days in your room in a fetal position. Did nobody pick up on that over there? I'm hoping that you will see. Yes. I know you're ready to get back there and do your job. I know you are. I'll try to wrap up. It's a tough time for a jury because they're like, get back there. Okay, you told me all this stuff. I'm ready. But please, when you go back there, think about how life really works. Think about what it took for them to get here. Think about how important these ideas that they were fighting for are. When you're considering damages, think about this. She looks a heck of a lot like her mom. And I think every time she looks in the mirror the rest of her life, she's going to get reminded of all of this. That's a long time to continue to live through something like this, again and again. Thank you.
Members of the jury, we're not quite finished with jury instructions. So what I'm going to ask that you do is go back to the packet of jury instructions that we were
discussing yesterday. And I know you all have your pins out. There's a couple of areas where my typing wasn't the best that we need to fix. So we're going to do that first. Okay, I want you to first go to page 13. And Mr. Reyes, do I need to go back to the other one, or you can, okay. Go to page 13. Under the little letter A, the 4th line down, where it says experienced in the past, and then there's a period mark, we need to add the words or in the future. So let's add the words or in the future. So it'll be or loss of capacity for the enjoyment of life experienced in the past or in the future. Okay. We all made that first change? Great. Our next is to go to page 19. Okay, down at the bottom, there's a paragraph that starts, Johns Hopkins All Children's Hospital admits. Immediately before that, we need to add the word, or the sentence, Johns Hopkins All Children's Hospital denies these claims. And so if you were to go back and reread the prior 2 paragraphs, which talks about Maya Kowalski's claims with respect to battery, we then need to add the sentence that Johns Hopkins All Children's Hospital denies these claims. And we all made that change. And the last page we're going to go to is page 41. And there are going to be 3 changes on this page. In the 3rd line, you see the sentence, but if you find for Mr. Kowalski, you should award them. Them should be him. On the 5th line, will fairly and adequately compensate them. The them should be him. And in little letter A, where it says co-pays incurred by the plaintiffs is Mr. Kowalski, because this is Mr. Kowalski's individual claim. Did we all get that, or do you need me to go over that again? Okay. Now that we made those changes, we're going to move on to page 64. And that's where we're going to start talking about the instructions again. 64. And do you all have the video monitor up? Great. Okay, members of the jury, you have now heard all the evidence, my instruction on the law that you must apply in reaching your verdict, and the closing arguments of the attorneys. You will shortly retire to the jury room to decide this case. Before you do, I have a few last instructions for you. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. That means if someone's in the restroom, you need to stop deliberating. You have to have everybody in the room. You will have in the jury room all of the evidence that was received during the trial. In reaching your decision, do not do any research on your own or as a group. Do not use dictionaries, the internet, or any other reference materials. Do not investigate the case or conduct any experiments. Do not visit or view the scene of any event involved in this case or look at maps or pictures on the internet. If you happen to pass by the scene, do not stop to investigate. All jurors must see or hear the same evidence at the same time. Do not read, listen to, or watch any news accounts of this trial. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you, such as a family accountant, doctor, or lawyer. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Any notes you have taken during the trial may be taken to the jury room for use during your discussions. Your notes are simply an aid to your own memory, and neither your notes nor those of any other juror are binding or conclusive. Your notes are not a substitute for your own memory or that of other jurors. Instead, your verdict must result from the collective memory and judgment of all jurors based on the evidence and testimony presented during the trial. At the conclusion of the trial, the court deputy will collect all of your notes and will give them to me, and I will destroy them. No one, including me, will ever read your notes. In reaching your verdict, do not let bias, sympathy, prejudice, public opinion, or any other sentiment for or against any party to influence your decision. Your verdict must be based on the evidence that has been received in the law on which I have instructed you. Reaching a verdict is exclusively your job. I cannot participate in that decision in any way, and you should not guess what I think your verdict should be from what I may have said or done. You should not think that I prefer one verdict over another. Therefore, in reaching your verdict, you should not consider anything I have said or done except my specific instructions to you. Pay careful attention to all the instructions that I gave you, for that is the law that you must follow. You will have a copy of my instructions with you when you go to the jury room to deliberate. All of the instructions are important, and you must consider all of them together. There are no other laws that apply to this case, and even if you do not agree with these laws, you must use them in reaching your decision in this case. When you go to the jury room, The first thing you should do is choose a presiding juror to act as a foreperson during your deliberations. The foreperson should see to it that your discussions are orderly and that everyone has a fair chance to be heard. It is your duty to talk with one another in the jury room and to consider the views of all jurors. Each of you must decide the case for yourself, but only after you have considered the evidence with the other members of the jury. Feel free to change your mind if you are convinced that your position should be different. You should all try to agree, but do not give up your honest beliefs just because the others think differently. Keep an open mind so that you and your fellow jurors can easily share ideas about the case. I will give a verdict form with the questions you must answer. I have already instructed you on the law that you are to use in answering these questions. You must follow my instructions and the form carefully. You must consider each question separately. Please answer the questions in the order they appear. After you answer a question, the form will tell you what to do next. Now, I'm going to now go over the verdict form. You do not have that. Mr. Reyes, I believe, is going to put it up on the screen.
I hate to interrupt your flow. I have one minor insertion on the verdict form before we do that.
Attorneys, please approach. Ninth grade typing teacher would be very upset at me. I made a hand change on the verdict form. It's the verdict form that you will have in the back, so I'll tell you where it is. But this is the verdict form. Is it up? Okay. We, the jury, return the following verdict. So ask you to go to the next page. 1. Did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 7th and October 13th, 2016? You will answer either yes or no. And the form will tell you what to do next. For instance, if your answer to question 1 is yes, please answer question 2. If your answer to question 1 is no, your verdict is for Johns Hopkins All Children's Hospital on this subclaim, and then you will skip questions 2 through 5 and go to and answer question 6. Question 2. What is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18 based on the false imprisonment occurring between October 7 and October 13, 2016? You put your answer there on that line. Please answer question 3. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for enjoyment of life sustained in the past? And then this is where I had to handwrite in, and to be sustained in the future. So you don't see it on your screen right now because I have just added it, but it is on the verdict form. I have handwritten it in this blue ink. Okay, so I'll read the whole question again. Number 3. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future, based on the false imprisonment occurring between October 7 and 13, 2016? The form tells you to answer question 4. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past, or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 7 and October 13, 2016? Please answer question 5. Under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 7 and October 13, 2016. You will either answer yes or no. Please go to question 6. Now, question 6 is the second subclaim for false imprisonment. Number 6, did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 18th and October 20th, 2016? You will answer yes or no. And again, the verdict form tells you what to do. If you answer 6 yes, you will go to question 7. If your answer to 6 is no, your verdict is for Johns Hopkins All Children's Hospital on that subclaim. You will skip questions 7 through 10, and you will go and answer question 11. Number 7. What is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18, based on the false imprisonment occurring between October 18 and October 20th, 2016? You will note I put a instruction. In awarding damages, please do not duplicate any damages you awarded in question 2. There's a line for your response, and the form tells you to answer question 8. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future, based on the false imprisonment occurring between October 18th and 20th, 2016? There's a space for your answer. Please answer question 9. 9. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future, based or until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 18th and October 20th, 2016? Again, there's an instruction not to duplicate any damages you awarded in question 4. There's a place for you to answer, and the form tells you to answer question 10. Under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 18 and 20, 2016. You will answer either yes or no. The form tells you to go to question 11. This is the beginning of the third subclaim for false imprisonment. Question 11. Did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted on January 6, 2017? You will either check yes or no. If you answer question 11 yes, please answer question 12. If you answered question 11 no, your verdict is for Johns Hopkins All Children's Hospital on this subclaim, and you'll skip questions 12 through 15 and go to and answer question 16. Question 12. What is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18, based on the false imprisonment occurring on January 6, 2017? In awarding damages, please do not duplicate any damages you awarded in either questions 2 or 7. There's a place for your answer. Please answer question 13. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring on January 6, 2017? There's a line for your answer and an instruction to answer question 14. What is the reasonable value of expense? Was the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be obtained in the future until Maya Kowalski reaches the age of 18 based on the false imprisonment occurring on January 6, 2017? In awarding damages, please do not duplicate any damages you awarded in questions 4 or 9. There's a space for your answer. Please answer question 15. Under the circumstances of the case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring on January 6, 2017. You will answer either yes or no. Please answer question 16. Now we're moving on to claim 2, which is battery, which is in 2 subparts. Question 16. Did Catherine Beatty and any bedside nurse committed battery on Maya Kowalski on January 6, 2017? You will either answer yes or no. The form tells you that if your answer to question 16 is yes, please answer question 17. If your answer to question 16 is no, your verdict is for Johns Hopkins All Children's Hospital on this subclaim. Please skip questions 17 through 20 and go to and answer question 21. 17. What is the total amount of Maya Kowalski's damages for psychological treatment incurred in the future after she reaches the age of 18 based on the battery occurring on January 6, 2017? Again, the form tells you in awarding damages, please do not duplicate any damages you awarded in questions 2, 7, or 12. There's a space for your answer, and then the form tells you to answer question 18. What is the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the battery occurring on January 6, 2017? In awarding damages, please do not duplicate any damages you awarded in question 13. There's a space for your answer. Please answer question 19. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child Maya Kowalski in the past or to be so obtained in the future based on Maya Kowalski reaches... I read that wrong. Let me read 19 again. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child Maya Kowalski in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18 based on the battery occurring on January 6, 2017? In awarding damages, please do not duplicate any damages you awarded in questions 4, 9, or 14. Please answer question 20. Under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the battery occurring on January 6, 2017. You will either answer yes or no. The form tells you to answer question 21. This is the second subclaim for battery. Question 21. Did Catherine Beatty commit one or more batteries on Maya Kowalski through hugging, patting, kissing, and placing Maya Kowalski on her lap? You'll answer yes or no. If your answer to question 21 is yes, please answer question 22. If your answer to question 21 is no, Your verdict is for Johns Hopkins All Children's Hospital on this subclaim. Please skip questions 22 through 24 and go to and answer question 25. Question 22. What is the total amount of Maya Kowalski's damages for psychological treatment incurred in the future after she reaches the age of 18 based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? In awarding damages, please do not duplicate any damages you awarded in questions 2, 7, 12, or 17. The form tells you to answer question 23. What is the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, physical or mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? There's a line for your answer and an instruction to answer question 24. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past, or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? In awarding damages, please do not duplicate any damages you awarded in questions 4, 9, 14, or 19. There's a place for your answer and instruction to answer question 25. We are now moving on to the claim 3, which is medical negligence. 25. Was Dr. Sally Smith an apparent agent of Johns Hopkins All Children's Hospital at the time and place of any treatment she provided to Maya Kowalski? You will answer either yes or no. If your answer to question 25 is yes, then Dr. Sally Smith is a healthcare provider for whom Johns Hopkins All Children's Hospital is legally responsible. Please answer question 26. If, however, your answer to question 25 is no, then Dr. Sally Smith is not a healthcare provider for whom Johns Hopkins All Children's Hospital is legally responsible. You will skip question 26 and go to and answer question 27. Question 26. Was Dr. Sally Smith negligent in the medical care of Maya Kowalski, and was that negligence a legal cause of loss, injury, or damage to Maya Kowalski? You will answer either yes or no. You will then go to 27. Question 27. Excluding and not considering the conduct of Dr. Sally Smith, were one or more healthcare providers negligent in the medical care of Maya Kowalski at Johns Hopkins All Children's Hospital, and was their negligence a legal cause of loss, injury, or damage to Maya Kowalski? You will check yes or no. Now, if your answer to either question 26 or 27, or to both of those questions, is yes, you will then answer question 28. If your answer to both questions 26 and 27 is no, your verdict is for Johns Hopkins All Children's Hospital on this claim. You will then skip questions 28 and 29, and you will go to and answer question 30. Now, if your answer to question 27 is no, and you did not have to answer question 26, your verdict is for Johns Hopkins All Children's Hospital. You will skip questions 28 and 29, and you will go to and answer question 30. Question 28. What is the total amount of Maya Kowalski's damages for loss of earnings in the past, loss of earning capacity in the future, medical, psychological, and nursing care and treatment expenses to be incurred in the future? There's a line for your answer and direction to answer question 29. What is the total amount of Maya Kowalski's damages for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of a disease or physical defect, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future. There's a line for your answer and a direction to answer question 30. We're now moving on to claim 4, which is the fraudulent billing claim. Question 30. Did All Children's Hospital fraudulently misrepresent a material matter in its invoices to Jack Kowalski or his insurers? You'll answer that yes or no. If your answer to question 30 is yes, please answer question 31. If your answer to question 30 is no, your verdict is for Johns Hopkins All Children's Hospital on this claim. You'll skip questions 31 through 33 and you will go to and answer question 34. Question 31. Did Jack Kowalski or his insurance company rely to their detriment on the fraudulent misrepresentation you found in answer to question 30? You'll answer that yes or no. And if you answer question 31 yes, you'll answer question 32. If your answer to question 31 is no, your verdict is for Johns Hopkins All Children's Hospital on this claim. You'll skip questions 32 and 33, and you will go to and answer questions 34. 32. What is the total amount of Jack Kowalski's damages for any deductibles or copays incurred as a result of Maya Kowalski's sheltering at Johns Hopkins or increases in the cost of insurance coverage in the past or in the future, including increased premiums, copays, and higher deductibles? A line for your answer. Please answer question 33. What is the total amount of Jack Kowalski's damages for the difficulty of finding insurance in the future? There's a line for your answer and a direction to go to question 34. We are now on claim 5, which is the survivor claim for intentional infliction of emotional distress for the estate of Beata Kowalski. Question 34. Did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski prior to her death? You will answer that yes or no. If your answer to question 34 is yes, please answer question 35. If your answer to question 34 is no, your verdict is for Johns Hopkins All Children's Hospital on both this survivor claim as well as claim 6, which is for wrongful death. You will skip questions 35 through 45, and then you will go to and answer question 46. Question 35. What is the total amount of Beata Kowalski's damages for pain and suffering or mental anguish caused by the extreme emotional distress prior to her death on January 7, 2017? Please answer question 36. Question 36, we're now in the claim 6, which is the wrongful death claim for intentional infliction of emotional distress causing death brought by the estate of Beata Kowalski. Question 36. Did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski that was sufficient to be a legal cause of Beata Kowalski's death by suicide? You will either answer that yes or no. If your answer to question 36 is yes, please answer question 37. If, however, your answer to question 36 is no, your verdict is for Johns Hopkins All Children's Hospital on this claim. You will skip questions 37 through 45, and you will go to and answer question 46. Question 37. Did the conduct that you found in question 36 create in Beata Kowalski an uncontrollable impulse to die by suicide? You will either check yes or no. Please answer question 38. Was the conduct that you found in question 36 a substantial factor in Beata Kowalski's death by suicide? You will either check yes or no, then you'll answer question 39. Question 39 addresses the damages of the estate. What is the total amount of any damages sustained by the estate for loss of net accumulations? There's a place for your answer. Please answer question 40. Now, questions 40 and 41 address damages of the surviving spouse, Jack Kowalski. Question 40. What is the amount of any damages sustained by Jack Kowalski for the loss of Beata Kowalski's support and services and funeral expenses resulting from Beata Kowalski's death paid by Jack Kowalski? There's a line for your answer. Please answer question 41. What is the total amount of damages sustained by Jack Kowalski for the loss of his wife's companionship and protection and for his pain and suffering as a result of Beata Kowalski's death? There's a line for your answer, and you'll go to question 42. Now, questions 42 and 43 address the survivor damages of Maya Kowalski. Question 42. What is the total amount of damages sustained by Maya Kowalski for the loss of Beata Kowalski's support and services? There's a line for your answer and a direction to answer question 43. What is the total amount of damages sustained by Maya Kowalski for the loss of parental companionship, instruction, and guidance in Maya Kowalski's pain and suffering as a result of Beata Kowalski's injury and death? There's a line for your answer. Please answer question 44. Now, questions 44 and questions 45 address the survivor damages of Kyle Kowalski. 44. What is the total amount of damages sustained by Kyle Kowalski for the loss of Beata Kowalski's support and services? There's a place for your answer. Please answer question 45. What is the total amount of damages sustained by Kyle Kowalski for the loss of parental companionship, instruction, and guidance in Kyle Kowalski's pain and suffering as a result of Beata Kowalski's injury and death? There's a line for your answer and a direction to answer question 46. Question 46, we're now in the seventh claim, which is the intentional infliction of emotional distress claim brought by Maya Kowalski. 46. Did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Maya Kowalski? You will answer that yes or no. If your answer to question 46 is yes, you'll answer question 47. If your answer to 46 is no, your verdict is for Johns Hopkins All Children's Hospital on this claim. Do not answer any more questions. The verdict form is complete. The foreperson must sign and date the verdict form on page 21. Question 47. What is the total amount of Maya Kowalski's damages for lost earnings in the past, loss of earning capacity in the future, medical expenses occurred in the past, and medical expenses to be incurred in the future? Now, in awarding damages, please do not duplicate any damages you have awarded in questions 2, 4, 7, 9, 12, 14, 17, 19, 22, 24, 28, or 42. There's a line for your answer and a direction to answer question 48. What is the total amount of Maya Kowalski's damages for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of disease or physical defect, and loss of capacity for the enjoyment of life, sustained in the past and to be sustained in the future? In awarding damages, please do not duplicate any damages you awarded in questions 3, 8, 13, 18, 23, or 29. Place for your answer and an instruction that your verdict form is complete and that the foreperson must date and sign the verdict form. Okay, we are now going to return to the jury instruction packet. We are on page 68. Your verdict must be unanimous. That is, your verdict must be agreed to by each of you. When you have agreed on your verdict, finish filling out the form, your foreperson must write the date and sign it at the bottom. At that point, please notify the court deputy that there is a verdict. You will remain in the deliberation room until I am able to assemble everyone to return to the courtroom, which may take some time. Once I ask for the jury to return to the courtroom, the foreperson will bring the completed verdict form. If any of you need to communicate with me for any reason, write me a note and give it to the court deputy. In your note, do not disclose any vote or split or the reason for your communication. I will tell you it will take some time for us to reassemble, because I think I have already told you that this room is going to be closed and people will probably be outside the building or maybe be off campus. So to the extent you are able to continue to work ahead, please do so, because it will take some time. Now, we're going to pause there before I go to the last instruction. There's a couple more matters, last minute matters we need to address. The first thing is what I have been dreading for 9 weeks. And there's no other way to say it. The law that allows for the deliberations only allows 6 of you to deliberate. I see some of you are shaking your head thinking that that might be the case. We have alternates. We had 6 alternates in case one or more of the individuals that are on the jury actually fell out. Yesterday you saw we lost, he was an alternate, but we lost somebody. And assume we had no alternates. Had that happened, we would have had to start all of this again. I will tell you, I've had trials that last a half of a day where I've lost members of the jury. For 9 weeks, until the day before the last day, we lost 1 person, is a testament to all of you. I feel horrible, or maybe the alternates are going to be relieved that they don't have to deliberate. But there's a couple of things that I need to tell you. As with yesterday, when I separate the alternates, I can't have the alternates interact anymore with the main jury. To the extent that the alternates have the main jurors' telephone numbers, you cannot use them to call the jurors until this is all over. Please don't have, I know you might want to talk to them, but you have to wait until this is all over. We do not want to have a mistrial at this point and have to start this entire process over. So in a couple of moments, I'm going to excuse the alternates. What we're going to do is the alternates are going to go back to the deliberation room. I'm going to leave the 6 jurors here. The alternates are going to get all of their materials that they might have in the back, and the court deputies are going to take you out to your car. To add insult to injury, I'm only ordered lunch for the 6 jurors because the county does not like me spending money for people who are not actually deliberating. So that's like the cherry on top of being told that you're the alternate, is you don't get lunch. And I apologize for that. I know many of you have jobs and that your employers have also put up with you not being there. I do have notes for those who may need them, and I'm going to hand this entire package to Deputy Coley, who will pass out those juror notes for your employers. I also have the sheriff's office has been so kind and actually ordered lunch, but you're going to have to take the lunch for the alternates. We can't have them back there. So At least now you have the cherry on top. You get lunch. That's very nice of you all. As I was saying, I also have some certificates for the jurors who are alternates. It in no way conveys the amount of appreciation that I and the parties and the lawyers have. You have put your life on hold for 9 weeks, and it's incredible civic duty that you have engaged in, and I cannot tell you how appreciative I am for your service and how sorry I am that you're not going to get to deliberate. Now, there's a few more things. The alternates know the names of the jurors, and you also know where they work. I'm presuming you know where they work. Long before this trial started, I entered an order that protected the names of the jurors until this is over. For the alternates, you may not disclose the names of the actual 6 presiding jurors or their location of where they work or any sort of identifying information about them until everything is over. Okay, do we understand that as a group of 11? I know I haven't told you who the alternates are, but do we all understand that the alternates may not disclose the names, where they work, or any identifying information of the jurors? We all understand that? Okay. Now, you have been given an instruction that you can't talk about this case, you can't do any research. After you are outside of this building, that instruction will end. At that point, you are free to talk about or not talk about this case. Just make sure you are outside the building. I do not want to have a mistrial because you all started talking about this in the presence of our jury. You will be free, like I said, to talk about or not talk about anything having to do with your experience, your thoughts, whatever. Totally up to you. And in a moment, I'm going to give you the official instruction on it, but let me kind of give you the Cliff notes on it. The attorneys and their agents may not approach you. You may approach the lawyers, but the attorneys will never be allowed to approach you unless you approach them first. Okay? You are free to talk to the media. You are free not to talk to the media. That's going to be totally up to you and as to what you individually want to do. I'm not going to tell you what to do other than you cannot say who those jurors that are actually deliberating are or where they work or any personal identifying information. I would ask you, though, to contemplate would the other jurors want their personal identity out there if they're not wanting to talk to the media. So I just ask you to consider that. If you want to leave your telephone number with Deputy Coley, he can give it to my judicial assistant, and when there is a verdict in this case, we can call you. You are actually free to come back, and when I say sit in the audience, we're actually going to close this courtroom so you won't physically be able to come in the courtroom unless and until the jury is actually in the room. But you're free to do that if you want. If you want to go home, that's fine too. And if you want to go to your favorite watering hole, that's also fine. Just no drinking and driving afterwards. Okay. So I'm going to give you the official discharge because as soon as I read you this, I've got to separate you out from the jury. And again, on behalf of all of the participants and the lawyers, the court staff, the sheriff's office, the clerk's office, thank you. Members of the jury, the alternates, on behalf of the parties, the attorneys, and the people of the state of Florida, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors, including the alternates. No juror can be required to talk about discussions that occurred in the jury room except by court order. Now, I know the alternates have not done any deliberations, but I'm just going to read you the instruction anyway. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to initiate any communication with you about the trial. However, you may speak to the lawyers or anyone else about the trial, subject to what my instruction was not to disclose the information of the deliberating jurors until this is all over. A request may come from those who are simply curious or from those who might seek to find fault with you, and it will be up to each of you to decide whether you wish to preserve your privacy as a juror. At this time, plaintiffs and defense, is the court able to discharge the alternates? Okay, the alternates are, and I'm going to use your jury numbers, juror number 106, juror number 115, juror number 137, 138, and 155. I have your certificates here and jury notes. Thank you very much. I really appreciate your service. We'll all rise as the alternates leave.
All rise. Jurors exiting.
And Deputy DiMizio, if you can get me their note packages and bring them to me so I can shred them. Yeah, I know their note packages are heavy. Everyone's been taking lots of notes. Okay, everyone can have a seat. There's a few more instructions we need to give because I need to give the alternates some time to get out of the jury deliberation room. Speaking of the jury deliberation room, this is important. I have stopped all sorts of cleaning services in that room on a going forward basis. So, there's going to be no one taking out the trash. Obviously, there's going to be food, maybe some smelly food. So, if you want your trash, give the trash can to the court deputy and we'll take care of it. Make sure that there's nothing in that trash that reveals anything, okay? But I'm more concerned about any sort of smelly food, so for however long you deliberate that you're not having to have that odor in there. But all cleaning services are stopped. No one's going to be going into that room. We are sealing that room. Even if you are coming back after a night break, no one's going to be going into that room. Your ability, like I said, you can go as long as you want tonight. If you want to order dinner, it will take approximately an hour and a half to 2 hours from the moment you say go to order dinner for it to come and arrive. So keep that in mind as you're deliberating. If you're going to want dinner brought in, give court deputies an hour and a half to 2 hour lead time so that they can arrange for that for you. If at some point you want to keep going tonight or call it a day, give us a note and let us know what you were thinking about as far as timing perspective. And like I said, when you send us a note, it's going to take us a little bit of time to get back together. So give us a little bit of a lead time. Like if you say you wanted to end at exactly 6 o'clock and you send us a note at 5:55, I'm not going to be able to get everybody here by 6 o'clock. So give us a little bit of heads up as far as what you want to do. Now, I'm not going to tell you when I'm going to stop you tonight if you want to continue to go into the evening, but at some point I will say, we'll bring you back tomorrow. You can go as little or as long in your deliberations. That is going to be totally up to you. Okay, so I did that one. You are going to have all exhibits in the courtroom. And Madam Clerk, are we now good with all exhibits?
Yes, Your Honor, I just need to find it.
I'm sorry?
I just need to put it in the book and that's it.
Okay, so, and I believe the attorneys both have reviewed the exhibits. They know everything is valid and that there's no inappropriate material. Okay. There is when I say there's a computer back there, it has no access to the internet. It's not connected to any networks or anything like that. But there are thumb drives of items that are admitted in evidence. So if you want to review the evidence that is on a thumb drive, you have that capability back there. If ultimately, though, that computer doesn't work for any reason and you need to hear something, what we will do at that point is you would send me a note to say, you know, we want to hear exhibit number X or whatever it is. We will then all reassemble, including the attorneys, and we will then address whatever that issue is. But if that computer is working back there, if you want to review an audio file, let's say, you can do that. We have also prepared a exhibit table of contents. And Alex, you have the thumb. And we also have an electronic thumb drive that has that table of contents electronically, so that if you wish to review a table of contents electronically versus in paper, you've got that ability as well. Whatever you want to do, if you want to do that at all. And the lawyers have checked that and made sure that that's the only thing that is on that thumb drive. If you end up not coming to a verdict today and that we are going to break for the evening, there's a question of what we're going to do with the verdict form. This is what we're going to do. I'm going to send this envelope back with you. There's nothing in the envelope. My assistant wrote verdict form, the case number on here. Okay. What you're going to do is when all 6 of you are standing around, you're going to place the verdict form into this envelope. You're going to seal the envelope, and then you're going to write, I would say, your juror numbers as opposed to your initials. When we bring you into the room, into this courtroom to say goodnight to you, we will then take that verdict form from you. The clerk of court will then place tape over your verdict form, and so that you will be able to see that no one has gone into your verdict form or seen that it's been reviewed in any way, shape, or form. And in the morning, the court deputy will give it back to you with the tape left on it, so that you will know for a fact that no one has reviewed that verdict form. Okay. I've talked about it's going to take a little bit of time for questions. I've talked about trash. Have the alternates vacated the building yet?
No, we're still waiting for the building.
I'm sorry?
We're still waiting on the building.
Okay, so it's going to be a couple more minutes because I can't, until they're out of the building, we're not going to do anything. As soon as the alternates clear the building, then I'll let you begin your deliberations and have that lunch that's been sitting there. building. Plaintiff's defense, may this jury begin its deliberations. Okay, members of the jury, this time you will take your notes with you. Okay, take the court instructions with you. Give the court deputies your cell phones and any type of electronic device with you, and at this time you may retire to begin your deliberations. We will bring in the evidence and the verdict form. All rise, jurors exiting. Okay, the jury's out of our presence. Are we taking
Yes, sir.
the evidence? Okay, we can do that. Madam Clerk, I'm filing the jury instructions as read, and I annotated that. Everyone can be seated for just a moment. Before you all leave, please make sure, when I say you all, the attorneys, make sure you leave with the clerk a telephone number that we can reach you. I would ask that before you disperse, kind of wait 15 minutes or so in case there's an immediate question from the jury. Try not to go more than 10 minutes, maybe 15, because I don't want to wait 30 minutes to reassemble, but I understand we don't have the facilities for you all to hang out here. A couple of other things. If the jury is still deliberating, come back at 6 o'clock and we'll discuss what we're going to do at that point in time. So if you haven't heard us before, make sure you're back at 6 o'clock. Any other issues?
Not that kind of
Okay. And one other thing that, I observed the jurors during closing arguments, and I would say that all of the jurors were attentive to both sides. And I will specifically note that juror number 1, for both sides during their arguments, continued his practice of taking copious notes, and there was no change in his body language or demeanor between the plaintiff's arguments and the defense arguments. So with that, we will be in recess
Your Honor,
pending.
just a question. Did you give a verdict form? Did you give them the physical verdict form?
Yes, I gave it to the deputy who handed it to them.
Just one. Just one.
Just one.
Just
One and only one. And I did the version that I annotated. That was at question 3. So.
I understand what you're talking about.
Okay. So with that, we will be in recess pending the call of the jury, and I'm going to ask that everyone please depart the courtroom. We are in recess.